that in any way there are shortcuts that we take to develop a vaccine. Health Minister Joe Qantas.
Mm. Sorry, I think it is.
Oh, sorry, Emily. I appear for the other respondents with my very junior, Ms. Litoli.
Thank you. Yes.
Morning, my lady. Advocate Thoms, appearing on behalf of the 22nd respondent.
Thank you.
Thank you, my lady.
Good morning, my lady.
Good morning.
My name is Rian du Plessis. I'm an attorney in Vanabel Park with right of appearance on acting on behalf of the 27th respondent, my lady.
Thank you.
Thank you, my lady. I was advised this morning that there were some of the papers that were not placed before my lady. I just want to establish from the court whether everything has now been placed before the court. They were in the court file, but had not been delivered to my lady.
What papers are these?
The condonation application, has it since been placed before my lady?
No, I've not. What is it in respect of?
It is in respect of the filing of applying affidavit and the heads of argument, my lady, but there doesn't seem to be any opposition to having those condoned. My net friends may just place that on record and confirm, my lady. Thank you.
Thank you. Counsel for the respondents?
On behalf of the first and second respondents, we have no objection.
Thank you, Mr. Kat.
We also don't have an objection.
Thank you, Mr. Mkari.
No objections, my lady.
Thank you, sir. Mr. du Plessis, thank you.
Thank you. Thank you, my
No
lady.
objection.
Is
from
Mr.
the-
Thompson here?
My lady.
Yes.
My lady?
Yes.
Advocate Thompson again. No objection from the 22nd.
Oh, yes. Thank you. Thank you.
Jeez, my lady, I was still muted.
Oh, no, that's fine. That's fine. Thank you. Thank you. Okay, you may
Thank you,
proceed,
my lady.
Ms. Norman. I'll have regard to the documents at a later stage. There's been various difficulties with exchanging papers in this morning. Case lines have really not come to the party. Let us down.
Yes.
But thank you very much. I received the I received the paginated bundles only yesterday, but that wasn't fatal because I had been able to go through most of the papers by then. But I have them now, and I have the consolidated indexes. Thank you.
Thank you, my lady. We're indebted to the court. My lady, this is an application. First of all, before the review application, there's an application for an interdict, which is contained in Part A, which my lady will find at page 4 of the record, where the SIU seeks an interdict against the first and second respondents from paying any monies to any of the other respondents that are cited in the application. Although that was not sought at an earlier stage, but it's since become even more important now that the court makes that order. But that is going to become apparent to the court after we've taken the court through the review process to indicate that there is no basis whatsoever that any of these suppliers could be entitled to receive payment arising from the tender in question.
Okay, Ms. Norman, I just want to clarify the issue of Part A of the application. I don't have the minutes of the case management meeting in front of me, but I seem to recall that the Free State government made an undertaking not to pay. I'm referring here to the government respondents in these proceedings, made an undertaking not to pay. And as a result, that relief was not persisted with by the SIU. And I seem to recall also that the respondent entities were very eager to have Part B heard. And as it were, there was an agreement that the focus should be on Part B. So I'm taken by surprise to hear you saying that you are persisting with this relief. And I have no doubt that the respondent entities may be completely not prepared, to deal with that, because that relief was put aside so that Part B can be the focus and disposed of as soon as possible in the interest of all the parties.
Maybe my learned friend for the first and second respondents may respond to that, because in the heads of argument, they do make an issue whether or not the SIU is persisting in that relief. My understanding was that the undertaking would have been made because the matter had not been heard by the court, and it would only survive up to the time when the court hears the matter. Of today, it was how the court understood it. But
no, that's not how I understood it.
Yes.
I understood
I ask?
Yes, I understood the undertaking to be in place pending the determination of Part B. Mr. Katz?
Yes, my lady, the paragraph 2 of the notice of motion makes it quite clear what the SIU is seeking. And that was, and I'll read it to you, my lady, that pending finalization of the review application referred to above, the first and second response be interdicted and restrained from taking any further steps towards implementation of the quotation in respect to the surgical gowns. Now, what happened was, and that applies to paragraph 1 of Part A as well. And my clients gave a solemn undertaking, which they stand by and they complied with, that pending the finalization of Part B, which is to be heard today, they would not make any further payments. Now, it stands to reason, to my mind, that if this application is refused or dismissed, then there is no Part A left anymore, because that which was pending in Part A has fallen away. On the other hand, if your ladyship makes an order in favor of the SIU, Part A's got no relevance anyway, because we couldn't pay in respect of a quotation which had been set aside. So Part A long gone, long water under the bridge, and it's absolutely irrelevant today. That's how we would see it.
Yeah, that's definitely how I understood it. I don't think I need to hear the respondent entities at this point, because this is favorable to you, unless there's a different point that any of you would like to make. Ms. Norman, back to you.
I accept that. Thank you, my lady, and thank you for that clarification. My lady, then coming to the review, some of the respondents, my lady, will get some of them, they question the reason why the SIU got involved in this matter and why the SIU has taken the approach and brought this application. But I think for the way we structured our argument, we need to start with the authority of the SIU, which is not disputed as contained in Section 4 of the Act, and also the fact that the President of the country deemed it fit when there were outcries about the procurement of the PPEs to issue a proclamation and join and direct the SIU investigate those particular tenders, which is exactly what the SIU has done. But most importantly, I think for the sake of because we will not perhaps just to touch on the issue of the contract, because some of the respondents, they say this has got nothing to do with the SIU because it's not a process issue, it's a contract issue. And I need to direct the court then to what is it that the proclamation actually enjoins the SIU to do. And if the court would permit, I would just refer the court to page 5 of the proclamation. That's page 55 of the paginated documents and page 4 of the proclamation. The proclamation is specific. The SIU should investigate matters which are listed A, B, C, D, E, F, and G. But maybe for completeness sake, maybe I should just Mention C, unlawful appropriation or expenditure of public money or property. D, unlawful, irregular, or unapproved acquisitive act, transaction, measure, or practice having a bearing upon the state property. And then E, intentional or negligent loss of public money.
Ms. Norman, I don't think we are on the same page. My page 55 is what page? Give me the page number for the proclamation.
For the proclamation. Thank you, lady. That will be page 4, my lady.
Okay. On which provision are you relying?
Maybe on page 51. I'm relying on C, D, E, and then what is important is the paragraph that goes below that. It says conduct took place between 1 January 2020 and the date of publication of the proclamation, or which took place prior to 1 January 2020 or after the date of publication of this proclamation, but is relevant to, connected with, incidental, or ancillary to the matters mentioned in the schedule, or involve the same persons, entities, or contracts investigated under authority of this proclamation, and to exercise or perform all functions and powers assigned thereto. So the contention, therefore, that this is not a matter that falls within the investigating process of a tender is clearly not correct in the light of the proclamation, the position that I've read. And also page 5, my lady, there it is specific under the schedule, because the proclamation directs the SIU to investigate the procurement of or contracting for goods, works, and services, including construction and all other matters that are not relevant to what we're dealing with today. Whether those are not fair, competitive, transparent, equitable, and cost-effective, contrary to applicable legislation, and conducted or facilitated through the improper or unlawful conduct of the employees. And lastly, unauthorized, irregular, or fruitless and wasteful expenditure incurred by the state or state institutions. So we round then that authority on those provisions of the proclamation. Most importantly, at page 836, the head of department, Mr. Mahlatsi for Health, stated that it is the
800 and sorry, Ms. Norman, 800 and
836, lady, and I will give the lady.
I keep missing you, so I don't have the page number. 8.
Page 836.
836.
Just 8. That's correct. Then I'll give my lady the paragraph, so that in the event my lady's papers are not in line with mine. At page 100, paragraph 150, 150.
Okay, let me get there. 836.
It's 836, and the paragraph number is paragraph 150.
No, clearly not aligned. Give me the page number for the document.
Thank you, my lady. Could just bear with me for a while.
The affidavit starts on her bundle 483.
Yes.
And then she'll have to go to.
And from your bundle, it starts from page 483, my lady.
Oh, 483.
483. Let's try and see.
Okay, I've got it. Yes, page number.
Page, and then the paragraph number. May we use the paragraph number, my lady?
Yes.
Unfortunately, yes. If my lady is comfortable with that, that would be paragraph 150, my lady.
Paragraph 150, I'm there.
This is what the head of department, Mr. Mahlatsi, states. the Free State Treasury openly reported the matter to the SIU and resorted to intense verification of these deliveries with the assistance of the officials from the Free State Department of Health. And then he continues again at paragraph 170, my lady.
Yes.
And the last sentence, the department became aware of the incorrect deliveries and immediately reported the matter to the SIU.
Yes, I understand the ground of opposition slightly differently based on the issue you are dealing with now, Ms. Norman. Remember the case for the Free State government, as well as the respondent entities, is that the procurement was regular. Their case is that the procurement was regular. So given that the procurement was regular, any issues pertaining to performance are not procurement related. They are contract related. That is their argument. And you may have seen the authorities that some of them rely on, you know, Steenkamp is one of them. Tabiso Chemicals is another. So that's how I understood the objection. So the objection doesn't, I mean, the fact that the matter was referred to the SIU voluntarily for investigation does not mean that there's any concession on their part that the procurement was irregular.
We understand that part, my lady, but they seem to suggest that all that the SIU needed to do was to look at the deliveries and maybe whether those were proper or not proper, but not to deal with the process, because according to them, the process was regular. So we're going to develop on this point because we are going to show that the process was so flawed that there was no ways that they could have lawfully concluded any of the contracts that they allege they have concluded. And it is on that basis, therefore, that we say that it is important to just show that not only did the SIU get the directive in the proclamation, but these departments themselves referred the matters to the SIU. And the question is, again, my lady, if then they believed, as they want my lady to believe, that this was a contractual issue, why would they refer it to the SIU? If they believe that this has got nothing to do with the powers of the SIU and the SIU should not interfere with it, why would they refer it to the SIU? I mean, they can't expect they refer a matter for the SIU to simply say, well, we'll confine ourselves to what you've referred us to, but the SIU's mandate was to investigate extensively, and it did that. Then we move on, lady, to the second aspect of the ground of review, and those grounds are contained in the founding, both the founding and the supplementary affidavits. The complaint again, but it's not a matter that needs to be addressed, but the complaint is that in the supplementary affidavit, there's more grounds. That is how reviews work everywhere. That's the purpose of delivering the report so that they can amend. So that's the amendment that we see in the founding affidavit. That's correct. Now, my lady, the second...
And they can't be prejudiced. They can't be prejudiced because they only answered after the supplementary affidavit has been filed. So there's no prejudice there.
At all. Thank you, my lady. Yes. Then, my lady, now we move on to deal with the process. My lady has pointed out to me that the stance that the respondents, including the state respondents, take is that the process was above board. There were no flaws. There is no room to interfere with the process itself. And we're going to do just a very simple exercise, my lady, to demonstrate how this process was flawed. But before doing that, I think it will be prudent to take my lady to the actual bid document. And my lady will find that is exhibit annexure NN2. And it will be on my lady's bundle. It will be from page 63.
I've got it.
Thank you, my lady. My lady, may I also have permission from my lady to refer to these pages? They may not be aligned to my ladies, where with the headings, according to the headings, with my lady's leave. Apologize for this. But my lady, what my lady has at page 63, my lady would have the bid document titled, there is request for quotations, supply and delivery of COVID-19 emergency personal protective equipment for Department of Health. And it has a date, a closing date being the 22nd of June, that is not an issue. And then the time is 11 for both bid documents and samples. Validity is 60 days. The following page, my lady, the heading will be documents in the bid document pack. And my lady will see that there down one, two, three, four, the sixth bullet point has declaration certificate for local production and content for designed sectors, in brackets SBD 6.2. And then the very last bullet point on that same page.
My lady, may I just interrupt? Sorry, I'm a bit lost and I do apologize, but I'm on case lines and the pages that my learned friend is referring to don't seem to align with my case lines numbers. So, I don't want to get lost when I argue from case line. So perhaps we can be on the same page. I'm not, so when my learned friend refers to pages in the record, those page numbers don't seem to align with what I see on my case lines numbering.
Okay, Mr. Katz, I received through my clerk communication, I think it was earlier this week or even towards the end of last week, I can't remember,
right,
that there are parties that are battling to navigate case lines. And there was a request that indexing is not generated from case lines. And I then granted a directive that in that case, we will not use the case lines references, that paginated papers should be prepared together with an index.
I see, yes.
Yes,
then,
so
yes.
Yeah, based on that directive, I assume that we are all on the same page of case lines, working from paginated papers, and there's an index.
Yes, no, that's right. Yes, no, my attorney had, I think last night, prepared a cross-referencing between the numbers, between the case lines numbering. I don't know if your ladyship has that, but I understand. So then I will try to mirror or cross-reference corresponding numbers in my argument to the extent necessary. But thank you, my lady. Thank you for the clarification.
Thank you.
Sorry about that. Yes.
Ms. Norman?
Thank you, my lady. Thank you, my lady. My lady, then the last bullet point on the page headed documents in the bid document pack, my lady would see that it says DTI local content declaration annexures C, D, and E. Then the following page, my lady, these are going to be relevant, my lady, when we sum up argument, these clauses that you're highlighting. Paragraph page, that will be bid submission checklist. My lady will see that it has SBD, I think the fourth line, 1, 2, 4, 5, 6th line. It says SBD 6.2, declaration certificate for local production and content for designated sector. And then just then below that, there's a BBEE certificate, SANAS accredited, where applicable. That would be fourth line from the bottom. And then the last bullet point will again be DTI local content declaration annexure CDE. Then if you move on, my lady, we page through, then my lady would find a document section 1. If we page through section 1, my lady will find on the 1, 2, 3, 4 page, third page, fourth page, I beg your pardon, that will be the pricing schedule, firm prices, goods, and the top right-hand corner, there will be CBD 3.1.
Where do I find CBD 3.1?
As my lady found?
No, I'm trying to find it. I see CBD.
It's entitled pricing schedule, my lady.
Yes, I'm there. I'm just trying to find CBD 3.1.
SPD, my lady. SPD 3.1. That will be entitled pricing schedule. SPD 3.1.
Yes, I'm there. I've got it.
That will be entitled pricing schedule.
Yes, I'm there.
Thank you, Thank you, my lady. My lady will find that, thank you, my lady, the category that you are concerned with is category B, and that has gowns. Then that category, my lady, has local content SBD 6.2 is applicable. My lady would recall that these are the 6.2 that we have seen earlier in the previous pages. But what is important about that is that it then gives the specification, and it says a gown, surgical, non-woven, polypropylene, body 54 GM, sleeves 66 GM, long sleeves with cuffs, reinforced in chest and forearm areas, resistant to liquid penetration, lint-free, non-flammable, bacteria barrier efficiency to comply with SANS 5379. And then it goes further. It says compliance certificate to be submitted. Sterile, individual, double. Peel packed. That's the specification. And then we move on, my lady. Let me just take my lady. I'm so sorry, these pages are really frustrating. I'm looking for. Then my lady, look, before my lady reaches, how am I going to do this? But ours is, if my lady could find SBD 6.2 that we have been referring to, it will be on the right-hand corner, about 6 pages away from where we were, my lady.
About SBD 6.2.
Sorry, I think it's SBD, my lady, 6.2.
I found it. Thank you.
Thank you, my lady. The heading there, my lady, is this: that declaration certificate for local production and content for designated sectors, and it's got general conditions which deal with the preferential procurement regulations and the specific BBEE regulations. But then it has 1.5, the local content LC expressed as a percentage of the bid price must be calculated in accordance with approved technical specific number sets 1286 2011 as follows, and it gives. And then at page 85, the following page, my lady, it gives the SAB's approved technical specification. And then at 1.6, it stipulates a bid may be defined if this declaration certificate and the Annex C in brackets local declaration summary schedule are not submitted as part of the bid documentation. Then we go further, my lady. Local content declaration, and it tells us a certificate must be submitted with a bid. And then if my lady could...
Ms. Norman, can I just ask you a question here?
Yes, my lady.
1.6 really caught my attention. Because your case is that the SAN certificate is mandatory. That's not 1.6, what 1.6 says. Makes it discretionary.
No, my lady, I'm still taking you through the document. We'll see where it becomes mandatory.
Okay.
Yes, thank you, my lady. I'll show my lady this. It's under the special conditions. If my lady could look at the document, it's preceded by a page marked section 2. There's a page marked section 2 as my lady. Yes, my lady. If my lady page is on, my lady will find section 2. 1, 2, 3, 4, 5, 6, 7, 8,
Section
9.
2 of
That's
the
10 pages.
document.
10 pages, my lady.
Okay.
10 pages. Thank you, my lady. Then, my lady, you'll find section 2. Section 2, then.
Okay.
My lady,
Please allow me to get there, Ms. Norman.
I beg your pardon. I beg your pardon, my lady. Yes, thank you.
Okay, section 2, yes, I'm there.
Thank you, my lady. The conditions and tells us how, if there is any conflict between the general conditions, which is the section that we finished, which was section A, and the special conditions. And it tells us in 1.1 that where, however, the special conditions of contract are in conflict with the general conditions of contract, the special conditions of contract will prevail. And then, my lady, the next page to that
Yes.
the next page is headed submissions of bids. And then paragraph 6 or clause 6 to that is National Treasury guidance.
I see
and
that.
Yes, thank you, my lady. It tells them from 6.1 to 6.4 what is expected of the bidders. And it says National Treasury has provided the specifications institutions must use to procure the basic protective equipment to contain and manage the transmission of the COVID-19 virus. National Treasury has set the maximum prices for the identified PPE items and cloth masks to reflect realistic current market prices. Suppliers are hereby invited for the supply and delivery of personal protective equipment that conform to the COVID-19 item specifications as issued by the World Health Organization and the National Department of Health. The specification is determined by the Department of Trade, Industry and Competition and the National Department of Health. And then if you look down under the scope of work, we see category B, gowns. Then the next page, my lady, then this is where we differ with the state respondent. It says requirements of the bid. Free State, Provincial, Treasury reserve the right to request bidders to submit samples for any item listed on the pricing list during evaluation. Deliver the required items to be specified provincial government building in Bloemfontein. Suppliers are required to supply and deliver items that meet specifications as issued by the World Health Organization and the National Department of Health. Failure to deliver products in line with the specifications will result in termination of the contract. But 8.5, this is very critical to the SIU's case. All certificates referred to as SBD 3.1 must be submitted at the closing date and time of the sample submission. Then below that, there is an NB, my lady. No samples will be accepted after closing time. But here is a note to that. All samples submitted for visual screening must be a true representation of the product which will be supplied. Samples of all items awarded against this bid will be obtained for the duration of the 24 months. And then we take, my lady, to the product, the next page, my lady. Clause 8.74, and that is product quality assurance certificates. All product assurance certificates referred to on SBD 3.1 must be submitted on the closing day of the bid and the closing date of the sample submission. Closing date of the bid and the submission. Then, my lady, coming to the point of the SANAS accreditation, if my lady may page through just 2 pages, after page over 2 pages, the third page, my lady, will have clause 14.1.10. The bidders are required to complete the preference claim form and submit their original and valid BEE verification certificate issued by a verification agency accredited by the South African Accreditation System, SANAS, or a certified copy thereof, or a valid sworn affidavit. And it then deals with all the SANAS certificates. And 2 pages down the line, my lady, after that, my lady, that tells us a responsive bid. And we get that at clause 18.1, responsive bids. Bidders must ensure that their bids are responsive by completing and signing, where applicable, all relevant bid documents and complying with specifications and special conditions of contract of the bid. So those are the conditions, my lady, that the bidders had to meet. And we have just done a brief exercise. I hope my lady has been finished with the record of the proceedings, of the Rule 53 record, I beg your pardon, the Rule 53 record, my lady, because the exercise that we are going to embark upon now, bearing in mind all the conditions that we've read in terms of the bid, and see whether there was compliance is contended by the respondents, including the state respondent. And the exercise that we've done, my lady, if I may wait for my lady to find the record 53 record, the Rule 53 record.
Where do I find it in the paginated bundles?
My lady, might I? It was deliberate separately. It would be marked. It will have a heading, my lady. Just found it from Stella. She marked it.
Something that was delivered to me.
It will have index to first and second respondents record dash Rule 53, and then below that it will have correspondence and documents in chronological order.
Okay, let me go through the index.
But that particular part of the documents, my lady, is also available on Caseline. But I understand my lady's directive not to resort to Caseline, but to the extent that it may be useful just for the record, because it had been updated, uploaded on Caseline.
Okay, I need guidance with finding the record on the index, because that will tell me where it is. Yes. Where do I find it?
Yes, my lady, if my lady I could just...
Which volume, in which volume is it?
The volume... Is that so? Yes.
Okay, can we just take a 5 minutes break while you organize yourself?
Yes, my lady, I just want... Yes. Sorry. I think my little friend, Mr. Katz, wanted to say something.
Yes.
They upload.
Yes, my lady, I do apologize once again, but I have insisted that my instructing attorney, sort the thing out, and I'm very clear instruction that my attorney did never receive your ladyship's directive concerning an index other than case lines. And I have to say that I prepared on the basis of that throughout on case lines. So it's going to be awkward, and I haven't been able to follow my learned friend simply because of that. I've done my best to look on case lines to find, pages that she's talking to, but I've never seen the directive. So I do apologize. Or maybe there was a slip up between the registrar's office and the instructing attorney, but it's a problem. So I have to point that out and place that on record. And I apologize for the mess that we find ourselves in. Anyway, there's nothing I can do, and I'll try and do the best I can, bearing in mind my inability to follow page by page my learned friend's argument.
Paul?
My lady, I just indicate where my lady would find it? My lady would find it in the court file. Just by text that
Ms. Norman,
display.
I just need to deal with the issue that Mr. Katz raises.
Oh, I beg your pardon, yes.
Mpo,
My lady?
who did you send the directive to regarding the indexing?
It was a request from Ms. Zondi, my lady, attending for the applicant, that we use index, the normal index that we are using now, because...
Was that communication sent to all the parties?
No, Judge, no. But however, the index was sent to all the parties.
No. So my lady, my instructions, which I'm reading now, are that we have never received an index other than the case lines index. We didn't receive your ladyship's directive, and we haven't received any index other than the case lines procedures. So that's why it's impossible for me to follow this argument.
Yeah, seemingly this wasn't properly handled, because any one party should communicate with all the other parties on copy if they need to get in touch with my office. And seemingly that was not done.
My lady,
yes.
If I may, my lady, an index was sent to all the parties yesterday, and everyone else.
No, Mpo. From what you've said, this communication was between you and Ms. Zondi, and the directive that I issued that that an index be prepared, not generated from case line. This communication didn't happen with all the parties, right? It was between you and Ms. Zondi. If you can just confirm that. Yeah, you see that. So that's prejudicial. That's prejudicial to the other parties. It doesn't affect my impartiality, because I wasn't even aware how this was handled between Ms. Zondi and Ms. Mashidisho. So how do we deal with this prejudice, Mr. Katz, because we are here now?
My suggestion from what, and I'll do the best I can, is if in the next few minutes, is there an electronic bundle referring to the index that can be emailed to me immediately? Because I just don't have, so when my learned friend refers to, for example, page 846, annexure blah, 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 if I can get an electronic copy of that bundle, I can follow. And then when I have to argue, I'll just do the best I can with reference to case lines. But it does put me in an awkward position. I can't pretend it doesn't. And I haven't followed for the last half hour. So when she refers to, for example, a particular annexure, I try to find it in case lines with some difficulty. I've managed, but I usually take a few minutes to catch up. So I do apologize. When I say to the extent that I can apologize, I can now see why it's not mine, not our fault at all. There was a slip up between your ladyship's registrar and the other parties.
Yeah. Okay. Let me hear how this affects the other respondents.
And we're fine, my lady. We did get the index, so okay.
So you are able to follow. Okay.
Yeah, we're able to follow.
Mr. Thompson?
My lady, I am able to follow. I am able to follow on the index received yesterday, my lady.
Okay. Ms. Duplessis? Mr. Duplessis?
Judge, I am following at this stage, if it pleases the court.
Thank you.
Okay,
how do we assist you, Mr. Katz?
If I could be sent immediately a paginated bundle of the pleadings, I can then follow. I'll just have, it'll be simple, and I'll just go to it very simply. I just haven't been provided with such a document.
Ms. Norman? So you actually need the paginated bundle, not just the index, not just the index.
The index doesn't help me if I don't have a paginated bundle, because if I've got an index that says page 845, I've got nowhere to turn to 845.
Yes.
So
and hence, when I heard about the request to work away from case lines, I anticipated this. Yes. And hence I made it very clear that if that indulgence is granted, then a paginated bundle must be delivered.
And we haven't received one. I can say,
yeah. Ms. Norman? Are you able to cure this
our understanding
shortly?
I could find out, but I'm not promising an electronic bundle because the bundle was made for the court. That was my understanding. That the bundles that were delivered for the court. A learned friend has got paginated papers. Surely he has prepared heads of argument, and that's the bundle that we are working. And the pages may be different. Surely he does have all the pleadings. He ought to have them. The difference in page numbers, the court has accommodated us because what we do, we make reference to a heading. And if it's NN1 and it's the B document, all the parties, they know there's only one B document. So I don't think it's an impossibility on his part to be able to follow at all. But my lady, maybe we could just 5 minutes to see how best we can assist him. But the other parties were able to work with the index that has been forwarded, and the court has been able to accommodate us. I just want to understand from him exactly what is it that he doesn't have. Thank you, my lady.
My lady, in our heads of argument, we actually raised this point before any of these problems that occurred. So in footnote 1, we said the applicant and the other opposing respondents have not uploaded the founding, supplementary founding, or the answering affidavit on case lines. And then we said, accordingly, when we refer to documents, we utilize the paragraph numbers only. I have been very alive to this problem for weeks now.
Yeah.
I mean, it's not as if it's not even hit me, you know.
Let's see if we can resolve it this way. I've noted that even Ms. Norman is not working from this bundle. And I say so because she keeps referring me either to a paragraph number or to a document page number. So she tells me, my lady, it's this document. This is where you find it in your index. And then from then on, once I know it's a big document, she stops referring to the paginated page numbers. And she refers me, she'll say, move 10 pages, move 3 pages. It's paragraph 1.6, it's paragraph 1.8. And that's how I've been able to follow, even though I could tell that she's probably not working from the same bundle. Are you able to do the same, Mr. Katz?
My lady, that's very useful. So may I just pick up on your ladyship's suggestion? I'll use case lines in the sense that when she refers to a particular document, if she says answering affidavit, page number 8 of the answering affidavit, paragraph number 7 of that page, I can then easily follow. And I'll just go to my case lines references because everything, as I understand it, is on case lines now. Heads of argument, founding, answering, Rule 53, it's all on case line. Supplementary affidavit, everything's on case line. So that would be very useful. If she can just identify which document, and she can go a bit slow with that because I've then got to accommodate the reference that she's making with respect to case lines. So I would pick up on your ladyship's suggestion. I think it's a good one.
Okay. Are you able to accommodate Mr. Katz in that way, Ms. Norman?
Yes, my lady. We'll try our best. Thank you. My lady was going to access my lady's Rule 53 record first before we proceed. And my lady had indicated that she would like 5 minutes adjournment to locate that.
I think we should adjourn for
30 minutes.
For tea. Do you need 30 minutes, Mr. Katz?
No.
We have a lot to go through. I didn't expect this extensive
litigation
approach from the SIU. So seemingly we need a lot of time for argument. So may I suggest that we just take tea at this point? Either 15 minutes or at the most we are back by 11:30. Shall we adjourn?
I need no more than 10 minutes. 10 minutes is fine.
10 minutes is fine? Okay, shall we make it 15 minutes?
15 minutes, my lady, as the court pleases.
Okay, Ms. Norman, before we adjourn, I need your assistance in locating this record. I just need to know if it was delivered with the bundles that were delivered to me. If not, if I should attempt to access it on case lines. If it's part of the bundles, please navigate me there.
Yes, thank you, my lady. It is on case line, my lady, but may I just establish from the attorney, and she will contact my lady's registrar during the tea adjournment. Because we are in Durban and she is in Pretoria, my lady. It's a bit difficult, and I just need to phone her and find out whether
fine. It's fine. I will access it from case lines.
From case as court, please.
I'll find it from case lines. Yeah, I just have discomfort with this direct communication that does not include the other parties.
Yes,
as you know, that shouldn't.
Yes, that shouldn't be happening. Yes, thank you, my lady. Thank you.
We adjourn for tea until 11:20.
Thank you, my lady.
Thank you.
Has my lady managed to access the records?
Yes, I have. Yes, I have.
Thank you. Thank you. May I direct the court's attention to page 135 of the Rule 53 record? From page 132 to 140, it's entitled June 20 Evaluation Sheet for Bid Documents.
Sorry, my lady, sorry to bother, but I had understood before the tea break that when my learned friend would refer to a document or a page, she would say what it is. So if she says page 135, I just don't know where that is. But if she says it's an answering affidavit, page 7 of the answering affidavit, I can follow. I thought that was the arrangement.
No, my lady, I'm referring to the Rule 53 record, which my learned friend's attorneys filed on case line. The Rule 53 record, and I did indicate that it deals with the evaluation for bid documents, and that document is item number 27 on the index, and it is pages 132 to 140. So it is the first and second respondents, I believe, that filed or uploaded this document onto case line.
I'm not going to say anything. I'm just going to follow because I've made my point. My attorney is busy indexing and paginating the papers yesterday on the basis of that which the state attorney sent her, yesterday, and she'll try and electronically send it to me in the next, as quickly as she's done it, all the pages. It's nearly 1,000 pages. There's nothing I can do. I'll just listen and just keep quiet as it pleases the court.
Mr. Katz?
Yes, my lady.
Are you able to access the records from case lines? Because I am on case lines now. Recall I said I wasn't directed to the record in the paginated papers. And I said, I'm quite happy to look at the record from case lines. It's one
Yes.
document, right?
Yes, I'm happy with
So
it.
I am on case lines now. I'm looking at the document. We've been directed to page 135 of the record. I'm not sure where the difficulty is with that.
There's no difficulty.
Okay, thank
I
you.
didn't realize that she'd said 135 of case
Of the
law.
record.
Right?
Okay.
The Rule 53 record is different to the pleadings record, and that's perhaps where there's some confusion. The record is a Rule 53 record, and in court parlance, a record can mean a pleadings record. So that perhaps we could just be clear about what particular record.
Okay. Okay. No, that's fine. That's fine. Thank you.
Thank you, my lady. That document, if my lady is at page 135, my lady, there's quite a number of entities that appear on that page, but I would like my lady to direct my lady's attention to an entity named Silver Power Medical. And
Yes, it's the last one on that spreadsheet, right?
On that spreadsheet, that's correct, my lady.
Yes.
It's Silver Power Medical. Before my lady, that is the 27th respondent. That is a party that is cited. Scrolls down that at page 135. My lady will see that there is a note in red right at the bottom, and it says no certificates.
I see that.
Thank you, my lady. Then we move on, my lady, to again page 134, my lady, of the Rule 53 record. And if my lady were to look for an entity called Yatola Projects.
It's bidder number 16.
That's correct, my lady. And that bidder, at the bottom of that column, my lady will also see it's highlighted in red, no certificates. And that bidder, my lady, is respondent number 32 before my lady. The very last respondent before my lady.
Okay.
Thank you. My lady, I am just going to deal with those that are before you challenging this application. My lady will, at page 133, my lady will see an entity, Holo Trading.
Please give me the name again.
Holo, my lady, SE. S for
bidder
sugar.
number 5, right?
Bidder number 5. That's correct, my lady. And that bidder number 5 is actually 26th respondent before my lady. And if my lady scrolls down in the same column that deals with that bidder, my lady will observe that that bidder, there is also no certificates.
Yeah.
And there is something that I'd like to point out to my lady in respect of that bidder. My lady will see under the column for gowns, my lady will see that that particular bidder actually filed a bid in respect of isolation gowns. It says isolation gowns.
Okay, I see.
Yes. Thank you, my lady. And then we move on, my lady, to page 132. Page 132, we direct my lady's attention to an entity called Bahuruti with a BA.
Okay, Bahuruti, I'm there.
Yes. And thank you, my lady. And that is, before my lady, a respondent, that is the 7th respondent before my lady. And my lady will notice that similarly, there is a comment, no certificates.
I see that.
Thank you, my lady. And I'd like to direct my lady again on the same page. My lady will see Newton Gate. Newton Gate on the same page, 133.
Okay, let me find Newton Gate. Okay, I've got a bit of a challenge here. Just give me a few minutes to find it.
Yes.
Still on 132.
Yes, my lady. 133. I beg your pardon, my lady. Did I say 132? On page 133, my lady. I beg your pardon. I'm so sorry. 133, my lady. 133. I'm so sorry. Thank you.
Okay, I'm there now.
Thank you, my lady. That would be Newton Gate. Newton Gate is the 20th respondent before my lady. And if my lady scrolls down in that column, my lady would find that even there is an entry, no certificates.
I see that.
Thank you, my lady. And I beg your pardon, I just want to make sure that these some of the lastly, my lady, again, my lady, page 135. Did I refer my lady to Silver Power Medical?
Yes, you started with Silver Power.
Yes, thank you. Then, my lady, at this point, this is the minutes of the quotation committee. Now, this committee, we're told that it's a committee that was dealing with the evaluation because the three normal committees, your evaluation, adjudication committees, were collapsed into one committee, and we are told by the state respondents that that committee was the quotation committee. But there is no date. There is no date as to when it held its meeting. But one thing is certain, that this happened after the close of bids. It could not have happened any other time. It only happened after the bids had closed. That is the 22nd of June 2020. Now, our submission, therefore, is this: at this point, when this committee met, these companies did not have the certificates. And my lady would recall that the special conditions that we read out earlier are mandatory, and they indicated that a bidder must file the certificates on the closing date. If no certificates were filed by that time, none of these bidders were compliant. None of these bidders ought to have been considered, because how we understand a bid to be a bid that is acceptable. The court told us in the Bopela judgment that a bid that is acceptable is a bid that, if I may just quote from the court, the Bopela.
Is it in your head? I can't seem to recall. Ms. Norman?
It is in our head, yes. Yes, it is in our head. Yes, my lady. We quote at paragraph 27 of our heads, and it gives a definition of an acceptable tender. That is paragraph 27, my lady, page 40 of our heads.
Thank you, I'm there.
Thank you, my lady. In the Supreme Court of Appeal, in that case of Sapela, stated in the paragraph that we quoted, the definition of the PFA must be construed against the background of the system envisaged by section 2171 of the Constitution, namely one which is fair, equitable, transparent, competitive, and cost-effective. In other words, whether the tender in all complies with the specifications and conditions set out in the contract documents must be judged against those values. And we submit that, my lady, at this point, after the 22nd of June, when none of the certificates had been filed, none of these respondents were responsive. My lady would recall that we had read the definition of responsive. It also refers to specification. So they ought not to have gone to any other stage. No orders should have been placed with them. They are not entitled to a cent of the money that belongs to the members of the public because they were just not compliant. We conclude that part of our argument that deals with the specifications, my lady, and we move on to the other ground, also dealing with the specifications. My lady would recall when we read out the conditions, I emphasized SANS 34, I'm so sorry, it's 5437, if I may just get that correct, SANS. If maybe would be with me, bear with me. 5379. SANS 53795. My lady will not find on the papers that have been filed by the respondents, they don't tell us when this particular committee met. It's not clear on the papers. They simply give a broad basis of what that committee was doing on the day. But our submission, which is what the SIU's case is all about, that when there was non-compliance with the specifications, they ought not to have awarded. Then the case of the SIU goes further. My lady would recall that when you read conditions, Treasury guidelines, they all emphasize that they must be with the World Health Standards and with the standards of the National Department of Health. Those standards can only be known by people that actually operate within that industry, because the acts that the Medicine and Related Products Act and the South African Health Product Regulatory Authority, those are the instruments that are used to measure quality assurance. And no bidder can file a bid that doesn't bear the SANS accreditation, that doesn't comply with the products and the Medicine and Related Products Act, that doesn't comply with the South African Health Regulatory Authority rules. None of these bids comply with those, and they ought to be registered, they ought to be licensed before they can distribute. But what the state respondents say to my lady is no. These were not products. So all of that you're talking about licenses is irrelevant. But my lady, we've made the point that these are devices. The gowns are devices. That's how they are defined, and we've made reference to that in our heads of argument. And we submit, therefore, that absent such compliance, there ought not to have been an award. Then the other ground that we make, when we deal with lapsing of the evaluation committee and the adjudication committees and the reasons that are advanced. The reasons are simply that because it's COVID-19, we didn't have enough officials, so we thought that we could just ask for approval. Yes, of course, there was an approval. But what we know is that during the time, subject to correction, the head of the Department of Health was also the head of Treasury at the time, during this time.
Sorry, just repeat that, Ms.
Acting as the head of Treasury. I beg your pardon, Maniji. The head, Mr.
That's submission, yes.
I beg your pardon. Yes, I was submitting, my lady, that at the time of the head of health was also acting head national treasurer of the Provincial Treasury. So the approval must be viewed in that context. That you really have one person who's got interest in the Department of Health and in the interest in the Department of National Treasury, of Provincial Treasury. Then the collapsing of these, my learned friends, they challenge us in their heads that we ought to have asked for that decision to be set aside. But the court can do that without us asking for it, because the court can do exactly what the court did in Kelland to look at the process that was followed. Because in Kelland, you had an MEC who had influenced the process, and you had an acting Director General who took a decision contrary to the one that was taken by the incumbent of the position, just to accommodate a particular bidder. So this too can be looked into, that to the extent that the court will find that all of the collapsing of these important committees, because these committees, they are not just there, they are there to monitor, the adjudication committee monitors what the evaluation committee does. Now, in this case, we don't have that. We have a task team, we have a quotation team, quotation committee. It makes these decisions, it looks at these bidders, and it says none of them have filed certificates, but it passes them. Nevertheless, were it not for that collapsing, which is what the SIU is complaining about, were it not for that collapsing, these very important, maybe this would not have happened, because an independent adjudication committee would have looked at the situation and would have said, how do we then pass these people who have failed to comply with the specification? Our submission, therefore, is that that collapsing is not as trivial as my learned friends try to make it. It is a very important component of the process of procurement. And the court must find that that too ought not to have happened. Then the other ground, my lady, that we rely on is, we've already dealt with the sanity. I beg your pardon, my lady, just ticking off on the conditions we've dealt, the technical specifications we've dealt with. The duties non-segregation. Yes.
Sorry, Ms. Norman, I left you talking all by yourself. I got disconnected. I'm back now.
I beg your pardon, my lady. I beg your pardon. My lady, we've covered the non-compliance with the various acts as all the grounds are raised at page, my lady will find them at page 14 of our heads. And we've dealt with the non-compliance with conditions of tender, which is in 28.1. We've dealt with the non-compliance with the technical specification. Lastly, then, my lady, before we conclude, if we may just take my lady to a very important report that comes from the first and the second respondents, that is the state respondents. I beg your pardon. My lady, we are now back to the documents. You are now, if we may move case line, my lady. This document is found in bundles that my lady has at page 391. And for my learned friends' convenience, may I just mention that this is exhibit NN75. NN75.
I'm there, Ms. Norman.
Thank you, my lady. Yes, my lady, that document, I hope Mr. Carter has found that document is entitled to bid committee, and it is a report on validation process conducted on surgical gowns. Is signed at page 370 by a Miss L. Riddles. And the date is 22 September 2020. This document demonstrates the irrational thinking of the first and second respondents in the light of facts that were staring them in the face, but they ignored and they decided to in any event award the tenders. My lady, it's an important document because what it does, it actually distorts the specification as provided for in NN2, as I've taken my lady before. The first thing that it does, paragraph 1 of that document, the report submitted to the bid committee is to give feedback on the validation process conducted at the health institutions on the surgical/isolation gowns. We know that the tender that you are dealing with had nothing to do with isolation gowns. The tender that this court is seized with has everything to do with surgical gowns. But then the mischief is going to be apparent later in this document as to why they decided to include isolation gowns, which are never part of the tender. And my lady would recall that one of the bidders had actually tendered, had never tendered for this, but had put up just to my note, had actually put up isolation gowns, and that is Seholo. That is the 26th respondent, as I've indicated earlier on. So this is misleading because the tender had nothing to do with isolation gowns. It had everything to do with surgical gowns. Then they say, my lady, they say that on 18 September, then they were informed that some stock delivered were unidentifiable and contents of the terms are not in accordance with specification. Of course, it says off specification, paragraph 2. That is telling, and any official employed to safeguard the interests of the public would have stopped this process here, because they acknowledge that there was no compliance with the specifications. And they know that if there's no compliance with the specifications, there can be no award of any tender. And she goes further, my lady. She actually describes what the specification was in paragraph 3, exactly the way that we have described it earlier. She goes further. She says that officials from FST, in conjunction with Department of Health, conducted on 21 September a validation check due to inconsistencies detected at the level of distribution of these products to health facilities. The validation process was conducted at the Universitas Crash and the medical depot. And then what is important is what she says to show how flawed this entire process was. She says in paragraph 5, FSPT then requested the 32 service providers affected to firstly identify with the FSPT where their stock were delivered, and for joint labeling of their boxes. This exercise was conducted between the representative FSPT and a medical professional from the depot in conjunction with the service provider. The chaotic nature in which the entire process was handled. And then in paragraph 6, they say, in light of the validation process conducted, following findings should be noted. 1, not all service providers were reached and cell phones were on voicemail and they did not return calls. Then she goes on to list all the problems that they were encountering. Then in Romans 6, my lady, maybe 5, maybe I should start with 5. Service providers did not indicate the sizes and quantities, and no indication of the name of the service provider was outside the boxes for easy identification. Romans 6, the items outside the boxes states surgical sterilized gowns, but what was inside the boxes were discovered as non-sterile isolation surgical gowns. There is no such thing There is no such thing as a isolation surgical gown. There's an isolation gown and there's a surgical gown. That's what they've presented in their bid document. And the non-sterile isolation gowns are not surgical gowns. Although this stock was received at different receiving points, the number of boxes received made it impractical for officials to identify them. And then it goes on and to say this, it says, upon verification in paragraph 8, an analysis conducted by the official in conjunction with the medical professional, it was confirmed that the items received cannot be regarded as wasteful, as these gowns can still be utilized for the treatment of patients affected with coronavirus. The use of sterilized gowns are only necessary for use at theaters and ICUs, as explained by the medical professionals. And they go further to motivate for this irregularity. For the use of these purposes mentioned above, the non-sterile gowns can still be sterilized by putting it through the autoclave, and the packaging will be a consideration factor in terms of the cost. The process involved will need the packing of the items, the taping of the packs, and the indicator, which amounts to about 6 Rand per sterilization. Other costs will be use of electricity and water. Now, this is the approach that the department is taking, that these gowns, although they are not according to specification, they can be salvaged. But looking at the cost involved, they are prepared to go and do that. And then they say, since most of the stock has already been distributed according to province, it is not practical to pinpoint each box to a specific supplier, and suppliers can therefore not be penalized. But then what follows thereafter, my lady, confirms exactly the case that the SIU has presented before you. They say, for instance, that 3 service providers that deliver the right quality, they say these are RAL conference events, Rise Now Trading, Luyolwe Holding. My lady would recall that I had referred, my lady, to, I want to check that I had referred to Luyolwe. Did I say to Luyolwe? No, I didn't. Okay. Oh, sorry. I beg your pardon, my lady. I didn't refer to that. But they say that these didn't deliver. They delivered the right quality. That is RAL Conference, Rise Now Trading, Medical, and Luyolwe Holding. They see 8 of the service providers lower than the National Treasury's price of non-sterile gowns, and they list them. And my lady will find most of them are the ones that are before my lady now. The 22nd respondent, the 32nd respondent, 27th respondent, 11th respondent, 12th respondent, 29th respondent, and 13th respondent. And then they say 21 service providers that quoted equal to the entry price of sterilized gowns but delivered non-sterile gowns. But what is this? How can the court be asked to condone something like this? That goes against the very principles of the whole tendering process in terms of section 217. And all of these, my lady, these parties are before my lady. They are the 9th respondents, the 7th respondents, 20th respondent, 14th respondent, 15th respondent, 17th, 26th, 5th, 10th, 18th, 23rd respondents. All of them are before my lady. And we go forward, they say FSPT and department could not confirm with the following service providers whether their stock was delivered. They list them. And those are also before my lady, the 28th, the 3rd, the 13th, the 14th, the 21st, and the 8th, and the 19th respondents. And they say to my lady, no, in their affidavit, just by looking at this report, there's an indication of a process that was not properly coordinated, that is flawed, that is contrary to specifications, that is irregular at every turn. And they are asking my lady to dismiss the application that the SIU has brought and to allow them to pay taxpayers' monies to people that had tendered and not delivered, not met the specifications, but quoted them was not supposed to have been delivered. And the case of the SIU, my lady, that there was no compliance with the specifications. And they try and answer, the 27th respondent, for example, tries and say, no, but we had the SABC test results. A lady will find the reply affidavit of Mr. Nikon Nebgen, and it starts from page 979 up to page 1025. 1025.
Thank you.
Thank you, my lady. My lady's attention is drawn to what he says in paragraph 76. I beg your pardon, this is not the 27th. This is the first, I beg your pardon, my lady, is the 7th, 15th, and 20th respondents' response. It's a response to the 7th, 15th, and 20th respondents. They put up an analysis certificate, which they say is compliant, and he's had to look at it. And he says this, only the second page of that report was put up by these respondents. The first page would indicate who the client was that submitted the sample and when this was done. And in the absence of this page, it is my respectful submission that these respondents are attempting to mislead the court. And then 76.2, he says all three respondents obtained their gowns from Raystar Trading with company number operating from 83 Ararat Road, Velcom Business, Velcom. TM1 records the client as MYZ Clothing. MYZ Clothing with company number that operates from 40 Red Street, Newcastle, KwaZulu-Natal. Raystar Trading is totally unrelated to MYZ Clothing. 76.3, it is also noted that certificate TM1 deals only with the measurable strength factors, International Organization for Standardization, relating to bursting strength and breaking strength of a sample of the material used to manufacture a sterile surgical gown. It does not address the measurable sterility factor of a medical device which constitutes the surgical gown. In this regard, he attached, my lady, the SABC test results of sterile surgical gowns provided to all departments of health. And those, my lady, will find as an annexer NN103 and NN104. And he says on page 3 of both reports, now these are the SABS reports, and with regard to specific line and proper cleanliness methods of tests, and it shows that it is also this certificate that was meant to be attached by the respondent, which was not done. So what he does there is to indicate why these reports that have been attached fall short of what they ought to address, which is the sterility, which he highlights in the preceding paragraph. And he says, Annexure TM1 is not compliant with the relevant standards and has suddenly been produced ex post facto. He's correct, because at the time when these were adjudicated, there was no report, no certificate that was filed. We make these submissions, therefore, my lady, to say, coming to the last point that they are suggesting to the court, they say to the court, yes, we understand that these people did not deliver what they were supposed to deliver, but there is a utility in taking these isolation gowns. We'll take them, we'll put them in an autoclave, we'll sterilize them, and then they will be good to go. But that is not the point of procurement. It's to turn around that tender. That on its own is review. What they are suggesting to my lady is something that is unheard of. That if you can go out and say, I'm issuing a tender to have 10 goats and somebody brings me sheep, this is still fine because you can still slaughter them and they can have meat out of them. That was not the purpose of this tender. This tender was very specific. It wanted surgical gowns that would accord to the specification, that would be used for the desired use by the Department of Health. What they are suggesting to my lady is not only wrong, but it is unlawful. And we base this, my lady, on a decision that we have not placed before my lady. It is not in our heads of argument, but my lady, this is a decision that comes from a judgment of the brother of my lady, Judge Matojani, J, and the case is Esorfanki, ESORFRNKI, pipelines.
Please slow down with the citation. I've got my mechanic J.
Yes, my lady. It's E for Esther, S for O for Oscar, R for Romeo, F for Frank, R for Romeo, A for Alpha, N for November, K for King, I for India, pipelines, Pty Ltd and another, versus Mopani District Municipality and others. In brackets, my lady, 40/13, close brackets, open square brackets, 2014, ZASCA, 21, semicolon, square brackets, 2014, number 2, all SA, 493 SA, 28 March 2014. This, my lady, involved an appeal relating to a tender that served before His Lordship Justice Matojani. And here the municipality issued tenders, invited tenders for construction of concrete reservoirs and welded steel bulk pipelines between the Nandoni Dam in Toriando and Sami Water Treatment Works in Guyana. Then there was a challenge to this tender because certain things were not done according, the party that was awarded did not meet the specification. That was the complaint. But what the court did in that matter, in order to assist both parties, the court, although it had signed the tender, but it allowed the contract to continue. This is what then the constitutional, the Supreme Court of Appeal says at paragraph, my lady, I printed this, the page numbers are not reflected, but the paragraph numbers are reflected. I beg your pardon. That will be paragraphs 20, 21, and 22. But 21 is important because the court says this, maybe the first line of 20, and I'll go to 21. The court says this: the need for the relief that is of declaring an act unlawful usually arises where adverse consequences flow from an order of declaring administrative action unlawful. In this case, in paragraph 21, however, the High Court, although correctly finding that the flaws in the tender process and award tainted it, and the contract nonetheless in effect ordered that the joint venture continue to execute the invalid contract under the municipality's supervision. No doubt it was the consideration of pragmatism and practicality that weighed heavily with the High Court in ordering, the continued execution of an invalid contract. It apparently made that decision in response to the claim by Esorfanki that an appropriate order would be one in terms of which it was to be declared the only successful bidder and the municipality be ordered to award it a contract to complete the work. The court found that the order proposed by Esorfanki raised a number of issues and practical difficulties, and that the granting of the order sought by Esorfanki would not serve to protect the interests of those who were to benefit from the construction of the pipeline. These issues, which it found not to have been properly addressed, included, inter alia, the logistical, legal, and financial viability of such a relief, and the extent to which the contract has been completed, the ownership of materials, whether if the balance of contract is legally and factually separable, it should be put out to tender. But then this is what the court says in paragraph 22. The decision of the High Court to give effect to a contract concluded pursuant to an unlawful tender is flawed for several reasons. And the court says, first, the parties to that contract had acted dishonestly and unscrupulously, and the joint venture was not qualified to execute the contract. But those are the facts outside these facts. But there is one ground which the SIU raises, that based on the evaluation report of the committee, it is clear that the committee knew, and at least Ms. Riddles knew, that there was no compliance with the specifications. There can be no justifiable reasons in law that would condone their acts, knowing that there was no compliance with the specifications as they say so in their report, but still continue to award the tender. But then the court says that the High Court then, by doing so, the court found that the order proposal raised a number of issues. Okay, and I'm sorry, I think I've read these issues which it found not to have been proper. It included earlier the logical, legal, and financial viability of the such review, and to the extent to which the contract has been completed. The decision of the High Court to give effect to that contract is what was criticized then by the Supreme Court of Appeal. And the court says a decision made in the exercise of the discretion in Section 8 of PAJA, we know that PAJA doesn't apply here, must be based on fact and not on mere speculation. The delay in finalization of the review brought about a change in the factual position, and it was the function of the court to ensure that it placed in a position to arrive at an informed decision with regard to an appropriate remedy. And then it says that then the court would take the competing interests, but there is a paragraph where it actually makes it clear that it is not open to a court then when the court has found that the process was so flawed that it was contrary not only to the tender itself and its specifications, but to the Constitution. It was not open to the court, therefore, to accommodate the contracts that were concluded in relation to that tender. Our submission, therefore, my lady, are that a case is made out by the SIU for the relief that it is seeking, that my lady should set aside this tender awards, and those parties that have already been paid were clearly paid unlawfully, and those monies ought to be returned. And we ask for an order of costs against all the respondents, including the first and the second respondents, whose interests in any event the investigation was carried, but in these papers they have really distanced themselves from the SIU and have made it their mission to protect tenders that they know are not compliant. Those are our submissions, my lady. Thank you.
Thank you, Ms. Norman. I've got a number of questions for you.
Yes, thank you, my lady.
My question relates to, the first one relates to the respondent's case, that this is a contractual matter.
Yes.
And not a procurement matter.
Yes, my lady.
I noted that the cases that, I think it's the 22nd.
The Steenkamp case.
Yes, the case that the 22nd respondent.
Respondent, that is correct, my lady.
For me to call them by their names later.
Yes, thank you, lady. Yes.
Yeah, there seems to be a contradiction in the SCA decisions, as it were, because you have Steenkamp.
Yes.
Who opens the door for procurement considerations where the difficulties were encountered at the performance stage.
Yes.
And then the earlier cases refer to actually draw a very sharp distinction between consequences that flow from performance, as well as consequences that flow from procedural irregularities.
Yes.
What should I make of those contradictions?
My lady, those have been overtaken by Kijima. Those have been overtaken by Kelland. Those are the decision of the Constitutional Court in this way. Those decisions show the Kijima decision. In Kijima, my lady would recall that the State Department, they decided to extend a contract several times without going out to tender, and concluded a contract with Kijima and ensured Kijima every time that, don't worry, we've complied with procurement processes, although Kijima never went out to tender. So what the Constitutional Court says in that decision, that where there has been no compliance and where the person is exercising public power, which is at variance with the principle of legality, and that is inconsistent with the Constitution, and that is on its own also at variance with the principle of legality. And that is, the Malaysia will find that in paragraph 40 of that decision. So what the court did, although the court sympathized with Kijima because Kijima had been misled all along, thinking that the State Department had actually done or complied with some of the procurement processes. That was the State Information Technology Agency. But the court says, well, the only thing we can do is that we cannot salvage, we can't say that the decision, that is the contract itself, ought to stay. And it says this at paragraph 54, my lady. I was just trying to get to this actual finding. Paragraph 54, the court says, in the circumstances, a just and equitable remedy is that the award of the contract and the subsequent decisions to extend it to be declared invalid, with a rider that the declaration of invalidity must not have the effect of divesting Kijima of rights to which, before the declaration of invalidity, might have been entitled. So in this case, I think Kijima had signed a contract where it had undertaken not to sue if there's any, if it discovers anything. But then the court, that's the only thing that the court did for them, was to protect them by saying that at least you have not waived your right, although it is there in the contract. But that contract cannot survive because it was not in accordance with the law. Then in the Steenkamp case, the way we see it, at the point when the contract, the challenge related to the contract, and I think that is how Steenkamp was decided. Then Steenkamp says, once a contract has been concluded, administrative law finds no application. But then Steenkamp happened way back, I think around 2007. But then the law, then I'm sure the courts discovered this. It would be easy then for a state organ to have a flawed procurement process, but rush to conclude a contract. And once it does that, it will say, sorry, you can't touch us. We've got a contract, administrative doesn't apply. That is what the court did, and it analyzed the principles in the Kelland decision. That not only is the court here supposed to look at the procurement process, but the court must look at the conduct of the officials. That's what Kelland did. That's what the court did in Kelland. Here we have placed before my lady the report of Ms. riddles. The Rule 53 record is very clear that by the time there was an evaluation, there were no certificates as expected in terms of the bid document. And that argument, my lady, that this is a contractual issue does not find application here, because the issues that we've been highlighting this morning, they are all process-related issues. They are all procurement process-related issues. And the contract ought not to have happened. It's not even a debate.
When I reflected on it, I actually thought that the facts here are distinguishable, because the performance difficulties that the department encountered flow directly from the procurement flows that you dealt with this morning.
Yes, my lady.
So if those procurement flows were avoided, the performance difficulties may not have arisen. So that could be justification for the special tribunal in this matter to look at the whole process holistically.
Yes, my lady. Yes, my lady. And because, in fact, my lady, my lady has to look at everything, because these PPEs, my lady, are going to be with us for a long time. We are in a period where we expect at least a Department of Health and the Department of Treasury to know that these are about the health of the people of this country. Yeah. When they allow people to tender products that do not accord to specification, in the hope that, as a department, you can always just sterilize them. That kind of attitude, this tribunal must show that it cannot be countenanced in a democratic society such as ours.
In fact, it struck me when I was reading that this paper, I mean, we've dealt with quite a number of PPE procurement matters in the special tribunal. And this issue is coming up for the first time.
Yes.
Right, it's coming up for the first time, and it appears to be an issue of huge interest to the medical supplies industry, right? Yes. Because if, based on your contention, that licensing is mandatory to either manufacture, wholesale, or distribute medical supplies, if the department just opts to source supplies from those who are non-compliant with the regulatory requirements for the industry, it has disastrous effects on this industry, right? Because it displaces those who take the trouble of complying with the applicable laws and the regulations in that industry.
Yes, my lady. That is so. And my lady,
to extrapolate it to the legal sector, it's no different if the state attorney can decide to ignore all the advocates and all the attorneys and then go out and just go on open tender and start giving legal work to anybody who believes they can do it.
Yes. And my lady, they have not the napkins were written in Mandarin, they were imported. They don't deal with those. And what it means is that that is why the 22nd respondent actually makes really, when you read how she says she was told that she's going to get, when she got the quotation, that's an indication that this is the person who does not operate within this industry. But now she's shocked that, this department is actually choosing me. I'm ecstatic. I'm going to supply this. She doesn't tell us who supplied her with these, where that person got those, who licensed those products. So it is a very serious matter, my lady. And as my lady correctly points out, it's very important to the members of the public. It is important to all of us as South Africans. In fact, as everybody who's in South Africa or anywhere else, for that matter. And it will set a precedent, because if my lady condones this kind of conduct, They are going to get these gloves made in my house, sent to them in the hope that they will simply sterilize them. That should not be tolerated. Those are our submissions. Thank you, my lady.
Okay, let's move to the issue of the remedy.
Yes.
I mean, it's become trite that the setting aside of a contract should never leave either the state or the successful bidders, albeit under an irregular contract, in a worse off position, right? So it's common cause on the papers that there are entities that have incurred costs. And I've heard you on the irregularities and the non-compliances that you complain about. But costs have been incurred, right?
Yes.
And goods have been delivered. And I hear you that you're saying Riddle and her committee actually have no powers to recommend salvaging the medical items. But this special tribunal, in terms of section 172, I think it's 22, not 21, 22 of the Constitution, has a wide discretion, to grant just and equitable remedy, precisely to ensure that no party, is left in a much worse off position than they would have been if they had not procured, right? Now, my question to you, and that's the all pay principle. Essentially, it's the all pay principle.
Yes.
We know from that judgment that the fact that procurement was irregular doesn't mean now you throw the baby out with the bathtub. I think one of the entities used that phrase, right?
For the 20th response.
Yes, and I see from the SIU approach, the SIU approach is really not interested in any just and equitable remedy. SIU is saying procurement was irregular, the goods is not what you needed, you shall not keep these goods. But this tribunal has a discretion, to explore that. And unfortunately, the parties are really not assisting me. The SIU didn't look at that because it wasn't of interest to it, right?
Yeah.
And on the papers, neither the respondent entities or even the Free State government actually give me comfort that if I were to order just and equitable relief in terms of which the goods remain with the department and the department uses them, the public will not be exposed to harm. You see, because these goods have not been quality assured, period. That they didn't say to the special tribunal, no, they've been quality assured to be used in a non-sterile environment. They're simply saying, oh, they can be used in a non-sterile environment, but that doesn't really assist them because the quality assurance difficulties that you have with the gowns remains. They are not licensed and some certificates were not submitted.
Yes.
Right?
Yes.
Now, how does one remedy this?
My lady, as my lady has pointed out, my lady cannot leave a vacuum after declaring this tender irregular.
Yes.
But we would urge my lady that the process that my lady would have to embark upon, my lady would exercise supervisory powers over the process.
Yes.
Instead of my lady simply saying that these must be utilized, my lady, I would suggest that lady maybe directs that a certain committee be set up which will include SANS, which will include SABS and SAPRA, pardon, all of these institutions, that they report to court as to what is there in those depots. I don't know how they're going to do that because some of the boxes are not marked. We are told that there may be some boxes which were donations. That's going to be a problem because one would not know who received what from which respondent. That's another problem. Then it would mean that my lady would have to set up a certain committee to deal with the matter and report to court. And maybe as the reports come, then my lady will be able to make more directives as to how the matter could be resolved. But as of now, because they have not given my lady a schedule, that we know that from the first respondent, we've got 20 boxes and they are marked properly. From the third, they are marked properly. It would be easy that way, because then the committee that my lady would appoint would look at those boxes and say, my lady, these are proper, they have been quality assured. Then my lady could direct that, then they be used, and maybe perhaps direct that they be paid half for those. I do not know. But the difficulty is that this whole thing is in a shambles. I don't know how the court is going to be able to assist. And there's also the issue of the debatement of accounts, to see whether what has been paid to those that have been paid is justifiable as well. So it is a supervisory order that my lady would have to give, with certain directives, certain things to be done within a certain period of time, and monitor the process going forward.
Okay, let me see if I've got further questions for you. I know that I'm delving into some of the issues that the respondents are raising, but I have you now, so
yes. Thank you, my lady.
Might as well deal with those issues.
Yes.
Now, this contract, and I think that's an issue that there's the 22nd respondent, another issue that Pileta raises, and that is that the procurement process did not only relate to gowns.
Yes.
Related to other medical items.
Yes.
But for some reason, the SIU just decided to focus on the gowns. So what are the implications of setting aside, what are the implications of setting aside the contract? Because I noted from some of the orders and the invoices.
Yes.
Because you see, if the gowns were ordered separately, it could be treated as a contract. But in some of the procurement, the way the procurement was done, different items were ordered as part of one order.
Yes.
Right. So what are the implications of setting aside the contract? Because there's no one contract for gowns. It's a contract for several items. What are the implications of setting it aside under those circumstances? And then the second question is whether these other items that the SIU did not focus on are not medical devices as well that are subject to the regulatory requirements that you complained were not complied with here.
Yes. My lady, the specification that is isolated from the contract relates to the gowns only. The one that the contract, yes, it does encompass all these other items, but the SIU decided to deal with this because there was non-compliance with the specifications that related to the gowns only. And I think it will be opportunistic of me, my lady, to say that then my lady must also direct that all these other items be looked into, because that is not the case that is placed before you. Insofar as whether then my lady can excise those other items from this decision, I think my lady is at liberty to do that, because there is no evidence before you that attacks those particular items, and therefore my lady could salvage maybe the decision insofar as those are concerned, because the SIU's case, and as it is presented, only focused on the gowns. And I think it is only fair that I also focus my responses to my lady to the case that is placed before you. However, having said that, if my lady is going to grant a supervisory order, there is no harm in my lady setting aside the entire tender and simply giving directions and supervisory orders in relation to all the items, because I think that would actually be a just approach, because then the entire contract, because if it cannot be salvaged, because the whole process, maybe they did it. A tender process, my lady in the supervisory order deal with all items separately.
Okay. Can you hear me?
Yes,
Ms.
yes,
Norman,
Malady.
are you still with me? Yeah, I think that's all I had for you. I'm just checking.
Thank you, Malady.
Thank you, Ms. Norman. Thank you very much.
Thank you, yes. Thank you, Malady. Thanks.
Yes, Ms.
May I turn off my camera, Malady, now?
Yes, please. Yes.
Thank you.
Mr. Cass?
Thank you, my lady. Your ladyship has asked some really important questions in our view, in our submission of our learned friend, and we intend to address all the questions that your ladyship has raised. But let me start with the last one. Your ladyship asked about the non-GAN issues. The first answer is the contracts are not severable. The second answer is there are parties who may have supplied surgical equipment or medical equipment other than GANs which are not joined. So the non-GAN issue doesn't arise. That's the first proposition that I wish to make. The just and equitable issues that your lady raises, we will address in detail concerning the type of order that your ladyship can make under 172(1)(b) of the Constitution, and in particular, both whether or not you uphold the challenge or if you do not uphold the challenge. And your ladyship will have seen from our heads of argument that even were your ladyship to reject the SIU's application, it may still be necessary for your ladyship to make an order which protects my clients in respect of the contractual issues that arise. Bearing in mind an important aspect, my lady, the type of investigation concerning the non-compliance with the tender and non-compliance with the contract, or the alleged non-compliance, my clients were dealing with on October the 20th, 2020, when they were told to stop by the SIU. And we've dealt with it in detail in our heads of argument. My clients were investigating what went wrong in respect of the performance by the service providers in respect of their contracts. And we were told stop by the SIU. And my clients may well be prejudiced or subject to litigation by the service providers were your ladyship, for example, to dismiss the application, and certain consequences would flow thereon. So we are very alive to what your ladyship would put as what is just and equitable in the circumstances. And my clients are very sensitive, as we put out in the answering affidavit, to this difficulty. So let me start off with how we see this case and what the case is about. Our first submission, my lady, relies on the Thabiso case. And we've heard your ladyship to ask the question, well, if there was non-compliance with the contract, could that be a reflection back or a shadow back on the question of whether the tender was good or not? And we submit that on the strength of the SCA authority in Thabiso, and my lady, perhaps I should, for ease of argument, ask my junior to put on the screen the paragraph that we would rely on, and it's paragraph 19. So in paragraph 19, the SCA, that's Brunt JA for unanimous SCA, says the following, and the last two sentences are the important ones. Are you with me, my lady? She's underlined it.
Yeah, if she can just zoom, the letters are very small, if she can just zoom in, enlarge the letters if it's possible.
But what Brunt JA says is, lest I be understood to agree with these comments by the court or quo, let me clarify, and this is the important proposition, lady. I do not believe that the principles of administrative law have any role to play in the outcome of the dispute. And other important words, after the tender had been awarded, the relationship between the parties was governed by contract law. And there's reference to earlier SCA authority. The fact that the tender board relied on authority derived from a statutory provision to cancel the contract does not detract from this principle, etc., etc. So, my lady, we would submit that there is a bright line between what happened before the tender is awarded and what happens afterwards in respect of the contract. The first part of, or the first part of the two-pronged relationship relates to administrative law, and that is your ladyship will investigate whether the principles of administrative law were complied with. And once that has happened, if whatever your ladyship does in respect of that issue, the second part of the relationship is dealt with by way of private law, contract law. And I'm not going to make the suggestion, my lady, that in no circumstances could your ladyship not have regard to what happened afterwards to determine whether the former was lawful or not. I won't say that. But what I will say is that in this case, what happened after certainly cannot impact upon what happened before. So that's my first submission. My second submission, my lady, perhaps there is one snag. In our heads of argument, there's a word that I asked that your ladyship change. In paragraph 2, your ladyship will have seen that we deal with an issue quite firmly, and the issue is whether or not, in determining the first part of your ladyship's task, or the only part, the administrative law part, is whether or not the decision is subject to pudger or not, an SIU challenge. And in the recent case, it's decided in June 2021 by the SCA, it's called Special Investigating Unit versus Engineered System Solution. Your ladyship will see it in footnote 4 of our heads of argument. Perhaps your ladyship wishes to add the following, or delete and add. In the second sentence in paragraph 2, we say the departments, that's
sorry, Mr. Katz, on which page do I find that footnote?
It's page, it's page 2 of the heads. Paragraph 2 of our heads. I know my junior, I see, has put it up, but your ladyship has our heads, so I don't need to.
Yeah, I'm talking about the footnote, because the footnote is not on that page.
There it is, my lady, at the bottom, that footnote. It's footnote 4. Special Investigating Unit versus Engineered System Solutions. Okay. I don't know if you have it, my lady. It's on the screen, but it's in our heads.
I was looking at the wrong head. Sorry.
Excuse me, my lady. Yes, it's there.
Okay, let me get there.
I want to make two changes, my lady. The second sentence in paragraph 2.
Yes.
Paragraph 2, we say the departments accept that the SIU's review, and we submit, there's a speed wobble there, is properly situated under, it should be under legality. And that your ladyship.
I'm actually very confused about this, because it's not a point taken in your answer.
No, my lady, okay. We mention it, we do mention, but it doesn't really matter. But my lady, the reason I raise this is because we submit that it's important that whatever submissions we make are accurate to assist the court in how this matter is to proceed. So It's not a pudger review, it's a legality review. And that you will find from paragraphs 24 and 25 of the SCA judgment. We don't believe, and we submit that it doesn't take the case any further, other than to say that our learned friends for the SIU do prevaricate on the Gajima line. Your ladyship knows that. We submit that issue, it seems to us, rightly or wrongly, has been decided by the SCA that this is a legality review, not a pudger review. We take it no further than that. So for them to come home, they would have to show that my client's conduct was irrational, etc., on the grounds of legality. It's not a pudger review. That's all I'm saying, no more than that. Okay. The next proposition that I wish to make, my lady, is this. Your ladyship knows that I've made the Tabisa point, paragraph 19. The next item that I want to address is this. Your ladyship will, in our submission, determine the lawfulness of my client's conduct as the law was at the time of their conduct. And that we know from the Constitutional Court judgment in Fedshaw from so many years ago. So it doesn't help to look at what what the law is today or how Treasury instructions change, because as your ladyship knows, once the pandemic hit, the Treasury instructions concerning procurement under Section 217 of the Constitution changed from time to time. So one can't, in a general proposition, submit that, well, take the view that the procurement process was fair in, say, 2019, and a different process in 2020, post-March 2020, must be judged according to those same standards that applied in 2019. It's a general principle. We don't believe it to be of any moment other than we will deal with how our learned friends, or how the SIU have challenged under legality my client's conduct. So what was said in Fetscher was the general principle asserted in Mhlungu and Du Plessis therefore remains applicable. As Mohammed DP held in Du Plessis, the lawfulness or unlawfulness of any conduct at the time it took place is determined by the applicable law at that time. So your ladyship will have to determine what was the applicable law in June through to August, from June 22, June through to August 2020. We don't believe that there's anything controversial about that proposition, but it needs to be emphasized that when it comes to whether we engaged in a fair, lawful process, the circumstances surrounding the procurement issues at the time ought to govern. The next proposition that I wish to make is this. Our learned friend, I think, has quite correctly suggested that the cause of action raised by the SIU in the supplementary founding affidavit is not to be disregarded because, as your ladyship pointed out, we had an opportunity in an answering affidavit to deal with that which was raised in the supplementary founding affidavit. That doesn't apply to the replying affidavit. The SIU is still bound by the general principles of motion proceedings that they may not make out a new case in reply. And your ladyship will disregard, our submission is, those, let's call it new causes of action, if I may put it that way, which are raised in the replying affidavit in light of that which my clients put up in their answering affidavits. And we submit on that point, there are two principles that your ladyship will have squarely at your ladyship's in the forefront of your consideration. One, the onus is on the SIU. They've brought us to court on causes of action contained in their founding and supplementary affidavits, not in the replying affidavit. Those causes of action and the facts which give rise to them are to be determined on the basis of Plascon evidence. And our version is the version factually that your ladyship will accept, together with the versions of the SIU, the applicants, which are not inconsistent with our answer. On that score, your ladyship will have seen from our heads of argument that my clients were involved in the procurement process. And we submit that what the deponents on behalf of the SIU do is rely on hearsay. And we're not here to take technical points, speed wobbles, that the hearsay evidence that they submit, that they put before the tribunal is inadmissible. But your ladyship will have regard to the inferences, the hypotheses that are drawn by the deponents, bearing in mind that they weren't there, in simple language. We were there. And when my clients who were involved in the process indicate what happened, then your ladyship will have regard to that and ignore, we would submit, or pay limited, if any, weight to any differences. Now let me start off by looking at what are the SIU's true complaints. Their true complaint is there was not...
I just can ask the hearsay point with you before you move on to the alleged irregularities, and I pondered on this hearsay point. and you're saying it's I'm trying to Mahlatsi, right? Is it Mahlatsi or Mabilo? I think it's Mabilo, the whistleblower.
Yes.
The one who invited the SIU. You're saying his evidence is hearsay because there was no confirmatory affidavit from him, right?
As it pleases the court.
Yeah, but the SIU conducted its own investigations. It called for records. It investigated the matter. It investigated the facts. So the SIU case is not based on Mabilo's evidence. In fact, Mabilo's evidence is very peripheral to the SIU case because all he said is that we've encountered these difficulties at delivery after the goods have been dispatched. Come in and have a look.
That's right, my lady.
And the SIU came in and conducted its own investigation, and the investigator then deposes to the founding and supplementary affidavits and the reply based on what he found.
Yes, my lady, that's the exact point. It's in paragraphs 15 to 19 of our heads of argument. And what we say is in paragraph 18, the SIU's affidavit is signed by Mr. Negben, who is an investigator. This is the point, my lady, your ladyship's point. He was not involved in the procurement process, but bases his affidavit, and this is the important point, my lady, on his personal knowledge. And then he says, that's what he says, not what we say, and or that gleaned from the reports obtained by myself and or those under my supervision in the course and scope of the investigation.
Yes.
That's what he says. Now, that might be so, and we accept that. We accept, that's why we're not asking for it to be struck. But how much weight do you place on that type of word compared to the members of the departments who actually did the adjudication, etc.? And that's what your ladyship will balance. And we submit that what the SIU deponent offers the court compared to what our witnesses, your ladyship will pay limited attention to what the investigator says, because it's hearsay in the true sense. He looks at a report, he looks at a document, and he draws conclusions about what happened. And let me turn to the certificate point, because it goes to the heart of our learned friend's argument this morning. If I understood her, she said that because there were no certificates, and this is 009833 of the case lines, and your ladyship knows this document is the document which is a declaration certificate is attached to a bid document, and that bid document was dated, well, it closed in June 2020. But in paragraph 1.6, the point is made as follows. And this is, we would submit, this is the heart of the SIU's case, of our learned friend's case this morning. 1.6 says, a bid may be disqualified if the declaration certificate and Annexure C are not submitted as part of the bid documentation. And if we understood the argument correctly, there were no declaration certificates, and that was the end of the process. That's how I understood it. But the difficulty for that argument is that the word may is the third word of 1.6. It's discretionary on behalf of those considering the bid. I learned it, my junior has put 1.6 on the screen.
Yes, you'll recall that I actually tried to debate it with her, and she said, hold on, I'm going to take you to other provisions that actually override this, and she did. So please deal with that. Go as far as that.
Yes, my lady, I'll come to that. Sorry, so when my lady, may I then ask, there's 8 points she dealt with. Let me just give it to you, my lady. There are other, and this is the point, this is the hearsay point. It comes back to the hearsay point. If I may just, I have a note on my, I have a note which I'm going to read to your ladyship. If your ladyship goes to 8.5, it should be considered with paragraph 8.5, must be considered with paragraph 8.7.2h. I'll just go back a step, which talks about bidders having submitted samples previously, and they're not required to submit samples and certificates again as they go together. That's the full answer, my lady. So to the extent that, as I understood her argument, my little friend's argument, and then your ladyship has it on the screen. 8.5, all certificates referred to must be submitted, etc. And then 8.7.2.8, which is a little bit down the page, if a bidder submitted previously, grammar there might be a speed wobble on the grammar, submitted previously samples for testing, has received feedback of the outcome, it will not be necessary to submit samples on the same item again for testing, etc. And one sees the full answer to the question in that regard. Now, what I submit, my lady, is bearing that in mind, one looks at, for example, the numbers. Now, the numbers, now just indicate the number. If one goes to 009150, there were 60 bidders. Only 7 provided certificates. 7 of 60. Bidder 11 provided certificates, but did not bid for the gowns. Bidder 24, the gowns were not acceptable. Bidder 34, price was excessive, etc. I give bidder 46, price too high. Bidder 47, acceptable. Bidder 50, not acceptable. So to suggest, my lady, that there was a, let's call it a slip between what happened and the law we submit has no foundation. And with respect, our learned friend didn't deal with these kinds of difficulties at all in our submission. The ladyship will see that my learned junior has just put on the numbers, which is 009150 on the screen. Your ladyship has it. I'm not going to turn. Your ladyship has it from case lines, and I've made the reference. And in consideration of the matter, your ladyship will have regard to what I've just said. So, my lady, what I'd like to do with your ladyship's permission is turn to our heads of argument and take your ladyship through it, because one will see that the kinds of general submissions, and they're very general that I've made up to now, are given effect to in some detail on every level in our heads of argument. And with respect to our learned friend this morning, there was no dent on any of the submissions that we've made in what we would submit our detailed heads of argument. In paragraph 4 of our heads of argument, we set out why we submit that the process was fair, and we've set out 6 steps. Perhaps I should just ask your ladyship to have regard to paragraph 4 of our heads, because your ladyship may wish to make a note that we submit. The first item was the request for quotations. That's item 1 were issued. 2, more than 60 bids were submitted. Samples were received and analysed by the specially constituted emergency procurement task team, which prepared an assessment report dealing with each bidder. Item 3, I don't know if your ladyship is with me.
I'm with you, thank you.
Yes. 3, the bid quotation committee evaluated in accordance with the criteria specified in the RFQ and the triple PFA and its regulations. 4, made a recommendation to the accounting officer, that was the head of department. 5, the head of department approved the recommendation on 5 July 2020. And 6, appointment letters were sent to the successful bidders. They are the 3rd to the 32nd respondents. There's no suggestion that that didn't happen in the way we've suggested. That's what happened. And then in paragraph 5, when the time came to deliver, certain but not all of the service providers delivered gowns that did not conform with the criteria specified in the RFQ. That's the difficulty in this case. No more, no less. The RFQ was clear. It was lawful, it was valid. It's the first item in the 6 items that I've set out in paragraph 4. And all that happened was that the department in September 2020, one sees this in paragraph 5, my lady. In September 2020, we were in the process of conducting the validation checks in relation to the products that had been delivered. The validation process, as you know, was complicated, as your ladyship knows, by the fact that the stock had become muddled with other surgical gowns which had been donated through the WHO and wasn't possible to identify, etc. And then there's a factual description right through, all the way through to paragraph 10. Your Ladyship sees that. And there's nothing that we would submit as far as the facts are concerned that the SIU take issue with. There's no factual issue. So the facts, as I've made the point already, the Plaskon-Evans rule governs. And in paragraph 10, the SIU, as Evans said in the replying affidavit, and we quote, the SIU, this is from the SIU's reply, only takes issue with the surgical gowns given the areas of non-compliance identified as regards the surgical gown, not the other PPE procured, etc. And then it says, my lady, the important thing, and your Ladyship's picked up on this morning, but I do need to emphasize it because it's the golden thread that runs through this case. This statement by the SIU confirms it's not the process, and I put that in italics, that they object to, but the deliveries. That's what this case is about. And I might sound like a stuck record, our heads of arguments sound like a stuck record, but if one takes to BISA, the clear wording in paragraph 19 of Brunt JA, this is what this case is about, contract. And we complain, I have to say, my lady, that the Department now is in an invidious position because this is continuing the whole of paragraph 11, and we explain the issue that I've already made. So there was a freezing, and we refer to the freezing in paragraph 11.4. And in paragraph 13, I do ask that your Ladyship have regard to what we say in paragraph 13. We also submit, and this really is your Ladyship's point, in paragraphs 13 and 14, that this tribunal ought to grant my clients just and equitable relief. My client comes in opposing this application, but we also seek just and equitable relief. And the relief that we submit would be appropriate would take into account the fact that the departments did not fail to pay the service providers of their own accord, but were instructed to stop payments by the SIU. The departments seek to be shielded against civil claims by the service providers for interest and other damages, and it's from the period 2 October 2020 to the date of judgment. So we ask, we understand completely that it's taxpayers' money that is at stake here. But the taxpayer needs to be protected by the tribunal because of what we would submit is the failure by the SIU to deal with this in a manner that is consistent with the principles under the proclamation by the President. So in paragraph 14, it says, against this background, we turn to deal with the principles. And we say that there's no merit in the grounds of review, and then there's certain principles which I have already referred your Ladyship to. Paragraph 25, the legal framework, and there are various which we would ask that the court have regard to in determining the matter. We don't believe that there's anything controversial about the issue. Subject to say that in paragraph 32, we raised the issue that in March 2020, the new regulations concerning procurement were issued under the Disaster Management Act, and we refer in footnote 28 to the ESAW judgment of the SCA concerning the national state of disaster. And there's a whole series of what we would submit are laws which we had to comply with, which we did. In paragraph 38, we conclude by saying that as set out below, the procurement that gave rise occurred prior to, and this is important, my lady, 25 August 2020 and during the life of Instruction Note 5 of 2020-2020, before Instruction Note 11. And this is not dealt with by the SIU at all. So Instruction Note 5 is clear. That was the law at the time of the conduct of my clients, and they complied. And then, my lady, there's a piece from 39 to 43, which we don't submit that the court needs to delve into, and that's the Odekral principle. In other words, that Treasury Instruction Note 5 of 2020-2021 was extant at the time of the conduct. And there's no suggestion by the SIU, for better or for worse, that instruction note was in any way inconsistent with the principle set out under section 207(1) of the Constitution. And then we explain in detail from paragraph 44 and following from 44 to 55, the facts of the procurement process that happened in this case. And my lady, I'm not going to repeat, but in our answering affidavit, that's paragraph 16 and following, it's in case line 009694. Those are the facts, and they're not challenged by the SIU. And these are detailed. It's not as if it's some high-level discussion of what happened. It's in detail, step by step by step. All my job today is just to highlight that those detailed steps suggested by my clients as to what happened are not put in dispute at all by the SIU. Then that's the point about the hearsay. They're conclusions drawn from hypotheses and inferences against the run of detailed evidence by those who conducted the facts. How much weight do you give hypotheses and inferences which from persons who weren't there, who have read ex post facto documents? And that's the question. So let me just give you a high-level taste of what actually happened. So in 44.1, we explain the Copter minister declared the state of disaster. Treasury in 44.3, etc., undertook procurement of surgical gowns. The process by Treasury was as follows, and then there's a detailed description. On 3 May 2020, the Director Asset Management submitted an application to Head of Department seeking approval to appoint only one bid committee for the PPE in relation to the COVID pandemic. This request was approved. And then it's all set out in our heads, and there's a reference to it, Annexure GM8 to the answering affidavit, case lines reference 009802. On 18 May, the members of the committee were appointed. On 4 May 2020, etc. And we go on in detail as to how that happened. On 18 May 2021, that's a mistake, that should be 2020 in 45.3. The Central Medical Depot published a department needs list, recording a need for 20,000 of these gowns. Around the same time, a database was established. It's case lines reference 009808. Authorization for a deviation approach suppliers to obtain quotes, all lawful. 17 June, approved the request for emergency procurement specifically for the Department of Health. And there was a deviation from the normal bidding process in terms of Treasury regulation. All this was done, and there's another deviation, 46.2, 46.3, 46.4. There's a request in paragraph 47. And now saying 49, my lady, it's an issue that your ladyship raised with our learned friend. The RFQ had a closing date of 22 June. It dealt with 5 categories: surgical masks, gowns, etc., gloves. Only C and D were removed from the scope. The remaining 3 were, yet it is only B, and your ladyship picked up the point. Analysis of the samples, explain it. And then, my lady, there's a whole series of evaluation, how it occurred in 52, 53, and following. And then in 55 and following is the events thereafter. And, my lady, I wish to emphasize paragraph 60. When paragraph 60, 2 October, whilst the internal investigation was ongoing and while the departments, my clients, were in the process of seeking cooperation, the SIU intervened and put a stop. 61, 9 October, the departments raised with the SIU the enormous prejudice that they would suffer if they are prohibited from using the gowns, from returning the gowns, and also from paying the service provided. Mr. Mabilo specifically sought clarity, and the SIU failed to give any answers. It's common cause. And now, my lady, I turn to paragraph 65, because this is really at the heart of this case. And your ladyship, in looking at the heart of this case, will do so with the factual basis that is set out in the answering affidavit in detail, which I've just given your ladyship highlights from. The grounds of review are 5. And those are contained in our colleagues' heads of argument, paragraph 28 of their heads. There are 5 grounds. 1, non-compliance by the, I think that might be a typo by them, but we'll leave it at it is. Maybe it's what they meant, with conditions of the bid, non-compliance by, I think it's all, again, I'm not sure who they're referring to, with the technical specifications, non-segregation of duties, and non-compliance with the Act. Procurement process followed was not aligned with the. All of those grounds are dealt with, each one of the 5, under the heading legality, are dealt with in detail. And there is no answer to our response to each of the 5 grounds. And we explain in paragraph 67 through to 73, we explain why ground number 1 falls to be rejected. I don't know whether your ladyship needs me to read this to you, but our learned friends have not dealt with any of these arguments at all. And we submit, for example, in 69, we say it may be correct, this is still under ground 1, it may be correct that one of the grounds which was required was the question of SANS compliance. But the suggestion that only a certified and competent individual can assess, it's not accurate. An item that is SANS compliant is marked as such. There's no requirement to test each gown separately in a laboratory. Furthermore, it is the manufacturer rather than the distributor, which is the entity that obtains this compliance from SARS. As they have, as the 27th, 7th, 15th, and 20th respondents have explained in their affidavits. There's no answers to that.
Mr. Katz, is it the Free State government's case that the gowns are SANS marked? It's not. It's not your case that the gowns are SANS marked.
No, the point up. No, it's a different point. My lady, the complaint. Let me try and answer it like this. The complaint, as we understand it by the SIU, is we set out in 67. And we deal with that in the following paragraphs. This is the answer. The SIU asserts the Treasury failed to comply, in particular disputes the task team, and asserts the gowns were not tested for SANS compliance by a certified. That's their complaint. By a certified and competent individual representing SANAs or individual had the relevant experience. That's the complaint, my lady. And we deal with that complaint. That's all we have to deal with. Well, that's the complaint, my lady. You'll see that footnote 62, SIU's heads of argument, paragraph 47. And we answer it in paragraph 68 and 69, 70. So we.
But isn't that the purpose of the certificate, which is their case? I mean, they've even put up a precedent of a proper certificate, which shows when was the sample presented for testing, who presented it for testing.
I'm not sure, lady. Are you talking, madam? Perhaps let me try and answer in the best way I can. If your ladyship is referring to the certificates that's referred to in 1.6 of the declaration attached to the bid, is that the certificate that your ladyship is talking about?
Mm-hmm. It's annexure NN. Actually, I still have it open. 103.
Yes.
There's a certificate that Mr. Nepkin put up. It is attached to his replying affidavit. It's the precedent of a SABS test report.
Yes, my lady. Now, what my client's answer is contained in the record of decision 00942 and 00944, page 24. And
sorry, I need to go there. Is it 24 of the record?
It's there. Well, my lady, if you look at footnote 64 and footnote 65 of our heads, you will see it there, my lady. Perhaps just go to, perhaps, my lady, the answer is in 68.1 and 68.2 of our heads. The emergency procurement task team were made up of Free State Treasury, supply chain and financial officials, as well as health professionals from the Free State Department of Health and the Central Medical Training Account Entity. Then 68.2, the appointment letters confirm that the emergency procurement task team was staffed by senior medical practitioners, Dr. Sagura, the clinical manager in the Free State Department of Health, and Mr. Gerber, a specialist nurse. These individuals were specifically tasked with assessing the samples of related product samples received for compliance and assessing the samples for compliance or non-compliance. They conducted an assessment received by each bidder. Each sample is assessed and marked as either acceptable or not acceptable. That's the answer, my lady. So we accept in paragraph 69 that one of the requirements was to be considered by this task team was the question of SANS compliance. So we accept that. That's why I say, my lady, it's hypothesis. We say we've complied, and what Mr. Nepkin says is we haven't complied, but he doesn't deal with this problem that we raise in respect of his hypothesis. That's why I keep saying, what are the facts? And we say that the suggestion by them, the SIU, that only a certified and competent individual can assess SANS compliance is not accurate. We say an item that is SANS compliant is marked. There's no requirement to test each gown separately in a laboratory, and etc. I've made the point, my lady. And then,
but the only case, Mr. Katz, is that the gowns are not sterile gowns, so it's not what was ordered.
That may be so, my lady. I accept that. My lady, we start off Tabiso. That's the problem in this case. Paragraph 19. So if gowns arrived which didn't comply with the bid specifications, that's something that your ladyship will have to, we submit, deal with under the just and equitable remedy that we can propose to your ladyship. We accept that. That's a problem, and we cannot, your ladyship can't get away from the problem. It's not an SIU problem. It's our and the service provider's problem, which we're going to make a suggestion to your ladyship how to deal with that problem, and we accept it. But it's not an administrative law problem. It's a contract problem. That's the golden thread that runs through this case. So if the gowns weren't sterile, if they weren't compliant with whatever they needed to be compliant with, we accept that. And that's what we were investigating in September 2020, and that's what we were prevented from finalizing that investigation because of the freeze order. And that's exactly the point. So your ladyship puts to me, the question is, the issue is that the gowns delivered were not SANS compliant. Well, I'm not saying we accept that, but that's the issue for the contract purposes, but not for administrative law problems. That's
how can it not be when your own records show the flaws in the evaluation of the bid regarding SANS compliance? You called for a certificate. Most of the bidders before in these proceedings didn't provide those certificates.
My lady, I accept that. But
and then later, deficient gowns are delivered. Isn't there a nexus?
Well, my lady, that's exactly.
Because I would have been, if I'm building a house, right, and I want to have recourse against the builder, I'll look for an HNBRC registered builder, right? And if the builder is not registered, that is warning bells to me, not to procure with that builder, not to contract with that builder, because if there are difficulties later, then I have no recourse.
No, my lady,
I'm not sure if this buttresses the point. This metaphor buttresses the point. But Ms. Norman makes the point that the minute you realize that these respondents have not provided you with SANS certificates, that the product, the items that they will be supplying you with are SANS compliant, you should have stopped right there. You should have disqualified them. So that was not done. That's not done. And then later on, it turns out there are difficulties with the products that were delivered.
My lady, I make a very simple submission. Your ladyship says that we should have disqualified them. We would submit.
No, it's not me, it's the SIU. I'm just debating their case.
No, I understand.
I'm going to have to make a decision.
Now, your ladyship's proposition to me. Yes, I understand.
Yes.
The answer is not that we should have, but we could have. The fact that we didn't is not a violation of any of the prescripts in determining the procurement process. Because for all your ladyship knows, let's assume we didn't disqualify them and they produced perfect gowns. Would we be here today? No. So you can't look at what happened ex post the tender and say, the tender was bad. What happens if they produced perfect gowns? The SIU wouldn't be here.
Mr. Katz, I'm actually quite alarmed by the Free State government's approach to this matter, because this is a time of reflection for the Free State government.
Yes.
And I'm very concerned going forward whether any lessons are going to be learned from this.
But perhaps
because this is not the manner in which medical items should be procured.
Milady, your ladyship says should, and I want to emphasize, and I made the point, if the lawfulness, the lawfulness of conduct is to be determined at the time of the conduct. We submit, and I'll stand by this, milady, that there was nothing unlawful as far as any regulation, Treasury instruction, any law.
No, your own bid criteria and your own specific conditions of contracts. I'm not even going as far as what National Treasury has said. Your own bid seems to be where you fail.
I'm not sure that, well, I'm not sure that's the case that the SIU bring, but, and it's not the case that I've been brought to court on. My case has been on specific causes of action under legality. That's the case. That's how we see it.
Yes, and there's been a lot of focus on the son's issue because it's actually quite central to the SIU case.
Yes, my lady.
Right. And I'm saying that's not in TI5. It's in your own bid document. I'm not looking at TN5. I was addressed on your own bid document.
No, I understand, my lady. I'm not, perhaps if the SIU could point to what's the problem with the own bid document, which paragraph of it, how it's...
That's exactly what was done, actually. I mean, I hadn't gone that far in my preparation, and hence I even said I didn't expect that extensive approach. You know, but that's exactly what Ms. Norman did.
But my submission is that, well, I don't want to sound like again, there is nothing problematic about our own bid document or any of the processes that we follow. I have the bid document in front of me. I don't see a problem with it at all.
Okay.
I mean, if your ladyship takes me to what, that's my submission.
No, you were here. You were part of the argument. Really, I don't have to take you back.
No,
you should you're responding to her argument. So you should be dealing with all those issues that she raised.
Yes, my lady, there isn't one issue that she raised which I submit has any merit. Not at all. The own bid document. I mean, that's, and it's, I make that submission on a very high level, but we've done that, sorry, my lady, with respect to, my lady, with respect. We are brought here in respect of founding papers, supplementary papers. We file an answer which deals with every one of the causes of action, and we explain why there's no merit in it. We do in detail, and it's not a question of just on a high level where I just say, oh, there's no merit in it. It's in detail. We file heads of argument. We explain that there are 5 causes of action on legality. Each one of those 5 are dealt with in detail in our heads with reference to the facts. There is nothing problematic about my client's process at all. But I do, my lady, perhaps if your ladyship, I'm not going to suggest that your ladyship isn't convinced, but your ladyship has seemingly indicated a prima facie view of a lack of appreciation by my clients of what they should have done rather than what they could have done. And I hear your ladyship. So we propose, my lady.
Because remember the SIU mandate does not only relate to instances where there has been corruption, right? So the complaint, from how I see it, relates more to inefficiency, or to use the word in the SIU Act, it's maladministration that results in loss to the state. That's really what this case is all about. And hence I put it to you that I'm actually surprised that the Free State government is not taking the opportunity to actually reflect on its processes and how it's been administering procurement in relation to medical supplies.
Lady,
this is what this opportunity presents.
And my lady,
I doubt if criminal prosecution will flow from, especially on the parts of the officials, right? There are allegations of fraud. Those respondents will deal with those. But on the part of the officials, I mean, from what is in the papers, it doesn't seem that there'll be any prosecution that will follow, because there wasn't. I don't see any conduct that falls into any definition of an offense. But what is really glaring from what the SIU case is all about is what appears to be gross maladministration in how medical supplies are procured.
No, my lady, we would submit that the question of the standard of maladministration or otherwise is to be determined against the backdrop of the regulatory regime that governs the procurement process. And I have, let me say it for the last time, and your ladyship will reject it, if your ladyship rejects it, there is not one piece of law, the constitution, regulation, treasury instruction that my clients have violated or not complied with at all. None. So when your ladyship says that there's an appearance of gross maladministration in the procurement process that was followed, we submit that there was not. And there's not one treasury instruction that we violated, not one piece of regulation. That's the submission. And we say that in respect of the challenge. What I do have to accept, and I do accept, is that once the process had been finalized, what happened thereafter, my clients were investigating. They were investigating whether there was anybody who was responsible for it, how it could be resolved, etc., etc. And they were frozen from doing so. It may well have resulted in what your ladyship says is a finding of maladministration by a particular individual. But we were never given the chance, and that which the SIU have put up doesn't bear scrutiny on that level. And those are our submissions in that respect. And my lady, I'm not, I don't want to waste your ladyship's time by going through the other four grounds. I've explained that ground, and it goes right through the heads. Ground 4 is on page 32 of our heads. And then we say in paragraph 97, and it's the golden thread, the distinction between award and post-award. Incorrect grounds were detected at delivery stage. And my lady, let me just say, the department immediately made the SIU aware of the situation. That moment. So I'm not sure what your ladyship means when we say, when your ladyship puts to me that this would have been an opportunity for the Free State government to reflect, because my submission is they did what in my submission is what a competent department would do with integrity. And we submit that in paragraph 98, the conclusion that those conclusions don't grant a review. But then, my lady, I do have to deal with this. In paragraphs 99 and following, the problem of just and equitable relief, which we submit your ladyship needs to deal with. And your ladyship needs to deal with it on both the basis that you find against me on the first leg. In other words, you find that there was something problematic in the process and you uphold the review, or even if you reject the review. So I accept that, my lady. Even if we win the first part of the case, your ladyship is still, we would submit, to consider what is just and equitable relief. And we've prepared a draft order.
If I find that the SIU has not made out a case, that's it.
No, my lady.
Section.
Sorry, with respect. The lady,
where do I get the jurisdiction to go beyond that finding?
172(1)(b).
But 172(1), please put it up. Actually, it's in your heads, right?
It's in your heads on page 90, okay. Paragraph 99 of our heads.
Paragraph 99. Let's look at it.
Now, my lady, it's not necessary that you do so, but we would submit that it would suit my clients that you do so.
Because that relief follows a finding of constitutional invalidity.
My lady, with respect, the Constitutional Court in Hoërskool Ermelo and a case called Minister of Safety and Security versus Van der Merwe have said that section 172(1)(b) relief doesn't only necessarily follow after finding under
I'm not
172.
aware of that case. Please give it to me.
My lady, it's her school. My junior will put it on the screen. But they're three big cases. And that's in fact what there it is, my lady. It's a judgment.
Sorry, that's the SIU decision, Anton. I'll find the Concord decision now.
Okay. Others? Do you have others?
Yes, I have. There's Minister of Safety and Security versus Van der Merwe, a judgment of the Chief Justice, where he reiterates the Hoërskool Ermelo principle. And there's also a judgment, Moslope, which was an IEC challenge to an earlier decision concerning addresses. And on Friday last week, the IEC went to the Constitutional Court relying heavily on 172(1)B to have the elections postponed without there being a declaration of invalidity or a review. So that's the jurisdiction of the court. Let me just say that it's not necessary that you turn to 172(1)B. It's not a must. But we would submit that for our clients and the respondents' sake and the taxpayers' sake, this needs to be dealt with, and I'll explain why. And the proposition that we're going to make applies whatever you find as far as the review itself is concerned.
Well, I see you actually deal with MLO in your heads.
The paragraph 78.
No, in 104.
Footnote 78. Footnote 78.
Paragraph 104. Yeah.
That's right, 104. That's right, madam. But so, my lady, what we submit. See, my lady, the difficulty is this: that whatever your ladyship finds as far as the review is concerned, there is still a problem. And the problem is what to do with what happened post the award of the tender. And my client's complaint, set out in 105, 106, is that the SIU has left my clients in an invidious position since their freeze order prohibited from, well, it did a number of things. It prohibited us, my clients, from investigating what went wrong. So your ladyship, perhaps, my submission is, not that your ladyship made a finding, but your ladyship's proposition that it seems that there's gross maladministration we would submit is unfair, bearing in mind that my clients did what, as I made the point, a reasonable and proper client department would have done. It was investigating itself. It reported itself to the SIU, but it was stopped from finalizing investigation for the reasons that you know. But in paragraph 106, we make the point that we weren't entitled to pay the service providers, and that was before Part A, before the proceedings in Part A were launched. We were also prevented from returning the gowns. We were prevented from investigating what went wrong with the gowns. So now, as a matter of contract law, Tabisa, we're late in making payment. We may face my clients might face claims for interest. We may face costs for damages from service providers and costs. There's a whole range of difficulties.
But Mr. Katz, there's a report by Ms. Riedel that deals with an evaluation of the goods that have been delivered. And that's where a determination is made that they can be used in a sterile environment. And then she recommends that there should be a discount of R1, and the department should resolve the matter in that manner. So yes, what do you mean you were prevented from investigating the matter?
No, the SIU issued, let's call it a freeze directive, that we weren't entitled to do that. And we complied.
Yes, what you were prevented from doing was acting on that recommendation. That's yes, my understanding. That's right. But you did investigate, yeah.
Well, we didn't complete the investigation because we couldn't, because of the timing. That was the problem. But the problem is this. Leave aside, I don't want to point fingers. Let's leave aside finger pointing for the moment. I'm not pointing fingers at the SIU for the moment. in respect to their freeze order. We know that they've got a mandate. We appreciate the mandate. We submit that the application today is misconceived and doesn't satisfy the principles of legality review that is required, irrationality, etc. It's a very hard hurdle to overcome. So yes, they say we should have done the following, and we say we could have done it, but we didn't have to do it. And we did it in a particular way which was lawful, not irrational. So the point is, in paragraph 107, we explain where all the problems arise, the grounds. And then we say we need a shield. And my learned journey will put up a draft order which we submit. The shield should contain whether you find for us or against us on the principle of the review. And it also, we would submit, satisfies three things. It satisfies my clients, let's call it holding the public purse. It satisfies the service providers. And it satisfies the, let's call it the public interest in the taxpayers' money. So the draft order that we...
What about the interests of the users of public health services, who are really the end users of these grounds, right?
Yes. So this is the order that we would seek, and it's along the lines of set out in paragraph 113.2 of our heads. So we say in paragraph 1, the relief sought in part B is dismissed. Now I understand that even if your ladyship is inclined to grant the relief sought in paragraphs 2 and 3 of the part B of the notice of motion, then paragraphs 2, 3 should follow nevertheless. And we submit in paragraph 2, the disputes regarding the alleged contractual non-performance by the 3rd to 32nd are referred by resolution by way of arbitration rather than by this court in a supervisory interdict type of way. So we would go to court, or they would go to court, and it would be worked out in an arbitration agreement as to how the issues of non-performance are to be dealt with. And 3, the service providers will have no claim against us for the period 2 October 2020 to the date of this judgment because of the freezing order and our compliance. And we would submit, with respect, appropriate compliance with the freezing order. And then, as far as costs are concerned, as your ladyship knows, we submit our process was not irrational, our process was not unlawful, and the causes of action set up in the founding paper and the supplementary paper are not sustainable, bearing in mind full answers given by the department. And those are our submissions, my lady.
Punitive costs against you, as asked?
Excuse me, my lady?
There's a request for punitive costs against your clients. Do you want to say anything about that?
Yes, my principal submission is that the SIU should pay our costs. We don't ask for punitive costs. And if they could show that there was corruption, that there was a lack of integrity, that this was all geared towards favoring some service providers rather than others, if that was shown, perhaps in that extreme example, maybe punitive costs could be awarded. But firstly, there's none of that. And second, the case is we didn't do what we could have done. That's their argument. That's not a sustainable cause of action.
Thank you. Thank you, Mr. Katz. I think we should take a lunch break.
Thank you, my lady.
How long? 30 minutes?
Thank you, my lady. Thank you. Thank you, my lady.
Okay, 30 minutes it is.
Thank you very much, my lady. Then am I the next in line, or who is the next in line?
Yes.
I think you should work it out among yourself. There's quite a lot of overlap in your cases, so I would urge you not to repeat what Mr. Katz has dealt with, to the extent that you rely on the same grounds of opposition, save where you would like to elaborate or to make a different submission.
Yes, because of the view that, subject to what my other colleagues are, then I prefer to come last than if they don't have any problem.
No, that's fine. I don't have a difficulty. Actually, I'd leave it up to you to to work out the sequence. It really doesn't matter. But it was important for me to hear Mr. Katz first.
Yes, yeah, of course, yeah.
Yes.
Yeah, it's fine then. Mr.
So I'll be
Thompson.
guided by you. You work out the sequence among yourselves.
Okay.
It really doesn't matter for me. What matters is that you don't, there's no need really to deal with, because your cases overlap. There's no need to deal with what, and a lot of you align yourself with the Free State government's case.
Yes. Okay. No, thanks very much then.
My lady, usually in court, one has the opportunity to ask the junior or the attorney if there's anything one says before one sits down.
Yes, I thought you've done that.
And may I take 10 minutes after the lunch break just to highlight some aspects that I've been told I need to highlight, which I haven't highlighted, as it pleases the court.
That's fine. That's fine.
Thank you, my lady. Thank you, my lady.
We'll adjourn until, let's make it 2:10. We'll adjourn until 2:10.
Thank you.
Thank you very much, my lady.
Thank you.
Thank you.
Afternoon, Judge.
Afternoon, Judge.
Please share the joke.
Sorry, good afternoon.
Share the light moment. It's been intense.
My lady, I'm just looking at Mr. Katz and he's not greeting back. That's why I had take the opportunity to greet.
He's not pleased with me.
No, my lady, let me say, my lady, I've been practicing a long time. And one of the frustrating aspects of practices are those judges or presiding officers who sit very quietly and I have no idea what they're thinking, and I'm not given an opportunity to deal with what their prima facie views are. So I'm certainly absolutely not in any way disenchanted or unhappy with you. I think you've given me a very fair and entirely appropriate hearing this morning. But my lady, I'd asked for an indulgence of taking 2 minutes of your lady's. I said 10, but it's going to be 2 minutes to say. Just 2 points. And the one point is to reiterate my golden thread, which is the division between the tender and the contract, the Tabisa paragraph 19 point, which we emphasize, and we submit that very firmly that what happened after can't reflect on what happened before. And that as far as the first part of the issue is concerned for today, there hasn't been any suggestion that there's non-compliance with a specific piece of law, regulation, or rule. That's the submission. The second aspect, which I've been asked, and I make the submission. So it's not that I've been asked and I make it because I've been asked. I make it as well. That your ladyship put to me, isn't this a case of gross maladministration in which the Free State or some of the Free State officials could reflect back and questions of punitive costs? And my submission.
No, I didn't. Sorry, let me just clarify. I raised that issue independently from the issue of cost, because my concern is if I find that if I uphold I'll deal specifically with the SANS related grounds of review, right? If I uphold those, and given the attitude you've taken here, are you going to sit back and reflect on those findings and look at your processes and compliance issues and manage medical items related procurement differently? That's really where I was coming from.
Let me
and
answer.
Also buttress, because I really got there's a sense of, for lack of a better word, very subtle irritation with the approach taken by the SIU, because in your view, you had this together. You had investigated, you had a solution a contractual solution that you're about to implement, and you really don't understand what the SIU is on about. And that's really where it came from.
Absolutely, my lady.
That comment. Yeah.
No, my lady, I take the comment, and that's what I wanted to address. In the first part was the golden thread. The second part was what your ladyship has now put to me, and I want to answer it like this. And I've consulted with those, not only my attorneys, but those who have certain senior positions within the departments. I've read what they've said to me by way of email, by way of WhatsApp, and I can tell your ladyship, well, let me submit, it's not, I can't tell, I mean, it's on the, you've got to look at what the papers are, that they all are very keen to have done the right thing. And they're very keen to do the right thing going forward in every respect of their lives. And there can be no suggestion, my submission is, that they would not be guided by whatever your ladyship finds. Subject, and I'm not saying that that it's not subject to an appeal, but your ladyship's insight, your ladyship's insight.
I often feel threatened when, in the course of argument, in the course of a primary proceedings, there's mention of an appeal.
No. What I'm saying is this. Sorry, let me take. It's not a threat. No, the point is this: your ladyship's observation is a correct one. That there is an irritation with what the SIU have done here. That's the point that I'm making. So when your ladyship puts to me, why is there this irritation with the SIU? Because they believe that the SIU have meddled and stopped them doing what they were trying to do, which was to sort out the mess. So what I'm trying to say is whatever your ladyship finds, and why I was saying that is I haven't never discussed an appeal. I don't even know what it is. I don't even know if the special tribunal is appealable. All I'm saying is that my clients have indicated that your ladyship is correct. There is an irritation because they believe that there wasn't maladministration, maybe wrongly, and your ladyship will determine it. But the point is that my submission is they have done the best. They've set out in detail what they did. There's been no hiding of the evidence. And your ladyship will recall at our case management meeting, it was my clients through us who tried to get this process moving. We have been all along. We are the ones, and that's my second submission, that we wanted to get this thing done in a way which is safe, secure, and proper. And that's the only proposition that I make. So to the extent that there's gross maladministration your relationship puts to me, I submit that on the evidence there isn't, and there wasn't. And that my clients have come to this tribunal in good faith, put out what they did. They believe it to be compliant with the laws and regulations, and they will live, and they have to live, that there's no choice, with whatever decision your ladyship makes. But what I do want to say, this is being televised, it's got media coverage, and my submission is that I think it's unfair that they should be tarnished and targeted by the SIU in the way that they have, when what they've done is, what we would submit is in line with the law. They've done it with integrity, and were there to have been, let's call it, your ladyship finds, a non-crossing of a T or non-dotting of the I, that's not for them to blame. And the last issue is that there's a case called Halifax, where were your ladyship to find that there wasn't, I hope I haven't discussed this with Ms. Patterson, but I hope she can put it on the screen, where were your ladyship to find that there wasn't a crossing of the T or a dotting of the I. It's called Halifax versus Mandela Bay Development Agency. It's an acting judge, but the principle comes from the paragraph that I'm now going to read to your ladyship, is that where there has been non-compliance with a crossing of a T, that's not the end of the matter. There still needs to be some materiality in respect of that which was done in non-compliance. So do you take a rigid or flexible approach? And we would emphasize paragraph 22 of the judgment, which says there are degrees of compliance with any standard, and as the SC held in Metro Project CC, it's notoriously difficult to assess whether less than perfect compliance on the one side or the other of validity to divide. And we submit this is due to the highly contextual and fact-sensitive nature of the inquiry, so that judicial pronouncements must be understood within this factual matrix of each case. There's no simple single formula, etc. And then paragraph 23 is nevertheless accept that compliance with bid requirements is necessary and has intrinsic value. We accept that. That's not what's before this court. Equal bid requirements, sorry, this bit lady, all bidders demonstrate the fairness 217, etc. And that's the only issue that we raise is, so then I just want to emphasize, as is emphasized on the screen, it must by contrast also be noted that there are inherent dangers in adopting an unduly rigid approach to the issue of responsiveness, and that course must guard against the classification of bidders based on administrative consideration as opposed to issues of substance. Such an approach could defeat the objects of fairness, transparency, competitiveness, and cost effectiveness, etc. So we accept as a general proposition that where there has been, what your ladyship puts to me, and I must accept, gross maladministration, we accept that in those kinds of cases, it follows that there should be some type of relief given to the applicant, in this case, the SIU. There should be some kind of review or declaratory order given, setting aside the process or make a review of the process. But not when there needed to be a certificate, but there wasn't, in circumstances where it has been explained. And that's the only proposition that I make in concluding that to the extent that your ladyship rejects my contention that there was compliance, such non-compliance as there was not one in relation to integrity, corruption, or any of the kinds of ills that plague South Africa on a daily basis in every department at every level of government throughout this country. So that's our submission on the alternative. Your ladyship rejects my primary submission as it pleases the court.
Yeah, you know, the SIU didn't use the word maladministration, right? It's in the Act, and I brought it up because that's what I'm seeing in the allegations, and I'm not saying I'm finding for them. I have to consider all the papers filed and argument advanced on behalf of all the parties. But I'm saying on the basis of the SIU case, broadly, that's how one would categorize the complaint. And hence I said they are not saying there's been corruption on the part of anybody, but the proper lens through which to see their complaints, they fall within the rubric of maladministration when one looks at the basis on which the SIU has jurisdiction to intervene in terms of the Act, right? And I think that's really where the irritation comes from, that nobody's corrupt. There's corruption in the country. We're not corrupt. Let us get on with our business. And I think that approach really misses the point, because when you read the scheme of the SIU Act, the SIU's jurisdiction is not only limited in instances where there's been corruption. In fact, if I find for them, this will be a classical maladministration case from the perspective of the jurisdiction of the SIU.
Yes.
Do you agree? I'm saying if I find, I'm not saying concede your client's case. If I find for them, this will be a classical. It will probably be the first, because most of the cases that come here is where, you know, somebody has put their hand in the cookie jar. There's no such allegation here.
There's a piece of it.
Yes, but that does not mean the SIU lacks jurisdiction in terms of the Act to come in and ensure that there's efficient administration.
I agree with you entirely, my lady, subject to the simple caveat that for your ladyship to find maladministration, which if you do find, I must accept, well, I don't want to concede because I don't concede that there was maladministration, but I want to make this point. In order to find maladministration under the heading of principle of legality, there needs to be some irrationality. So maladministration, as Halifax points to, isn't sufficient to justify a review. There needs to be more. The maladministration must lead to some ultra vires, and there isn't, well, I know there are suggestions of ultra vires. I submit that they haven't proved it, or a lack of rationality. And what rationality means in this context, we would submit, as the Constitutional Court has said over and over, starting with pharmaceuticals, there must be a disjunct between means and end, and that the means adopted to achieve the ends aren't rationally related. And we submit, my lady, there's no suggestion of that. And that's why I come back to what is this case about? Principle of legality. And your ladyship may find there hasn't been a crossing of the T. There hasn't been a crossing of the I, a dotting of the I, sorry. But that's, the problem is, have they made out a case on the principle of legality? Is what happened ultra vires? No. Is what happened irrational in the sense, the classical sense, pharmaceuticals, Democratic Alliance versus President Albert? The answer is there hasn't been such. Our submission is your ladyship will not come to a conclusion of irrationality in that maladministration sense, as it pleases the court.
Yeah, let me ask you a question that popped up during lunch when I was reflecting on our engagement, and it's something that came up towards the end of your address in relation to your reliance on MLO, right? Now, if I'm with you that this is a purely contractual matter, on the basis of the Breedenkam judgment, why must I even intervene?
I accept that, my lady. I accept you don't have to. My submission is this. Well, let me say, 172.1 is introduced by the words, when considering a matter within the court's jurisdiction, a constitutional matter within the court's jurisdiction. And to the extent that you're dealing with respect, my lady, an organ of state, the Free State government, which complains that the SIU has put it in an invidious position, your ladyship may, no, don't have to, come to the conclusion that you see potential conflict between the service providers and the Free State organ of state, and your ladyship may wish to give just and equitable relief in that context. If your ladyship is of the view that it's not necessary, we live with that. We're not. It's not a prescript. It was an offer. I have no idea what the service providers are going to suggest because they may have some other idea. But we'll just and equitable. You have a very wide discretion. You can do anything that comes to mind in your supervisory.
But it has to be in accordance with the law, you see, because that's how we mess up our jurisprudence when we resort to relief that is at odds with principles that have been formulated in other judgments.
I accept that. So, for example,
and I see the same is happening. There's one party. I think it's Piletti that does the same with my judgment in Marseille. So one needs to be very, very careful with what is being proposed to the judge, and not be oblivious to other principles of law, so that we really don't mess up our jurisprudence.
Well, for example, my lady, just to take your point a little bit further, for example, let's say Mr. Mokari, I see coming in next. Let's assume his client sues. Let's assume your ladyship dismisses Part B because you find that they haven't met the principle of legality standard. And his client sues my client and my client chooses not to pay because there was non-compliance with the contract, the Tabita. And my client defends the claim, whether it be through arbitration or through litigation in whatever way. My client would have all the remedies that would be available to it under the law. So I accept that, my lady. I do accept that.
Okay, thank you.
Thank you.
Thank you. Who's next? I really enjoyed our engagement, Mr. Katz.
Yes, my lady. My only regret is that it wasn't in person. Thank you.
I tried to get you here. Was it you that I tried? No, I think it's the matter I had last week. I tried to twist their arms to get them to court, and they didn't agree. So I wasn't going to try it with you. And I saw that there's a complaint by the Bar Council that's been sent to the Judge President that judges are forcing counsel to come to court and exposing them to harm. So I didn't want to do that to you.
Well, let me say sometimes it's not unpleasant to be exposed to the harm, the potential harm. Thank you, my lady.
Thank you.
Yes,
Who's next?
My lady, it's me. We have agreed that I'll start first.
Okay.
That would be the 7th, the 15th, and the 20th.
Yes, I call them the new gate respondents.
Oh, okay.
Yeah.
Well, with regard to the service providers, I'll just call them service providers, their participation is quite limited in the sense that if you look at the notice of motion Part B, prayer 1 and 2 squarely relates to the state respondents, that is the department. We have very little that we can say insofar as that is concerned because we did not appoint ourselves, but we were appointed on invitation. Case law is very clear what a tender is. A tender is an offer that is made by an organ of state, which is made transparently and openly to those who can make their services available. And it is up to that organ of state to ensure that it complies with the requisite provisions of the law, Section 217, the supply chain management policy of that organ of state, if it does have one, PPFA, and as well as the Public Finance Management Act. So that responsibility entirely rests with an organ of state, not with the person invited to render services. So we're simply invited openly and transparently, and we tendered and we competed openly with anybody, and we were appointed. Upon our appointment, we rendered services. Well, before we rendered services, then contracts were concluded with us, and we had to be remunerated for that on the basis of a quid pro quo basis. So the relief that we are opposed to which we say that was completely unwarranted, is paragraph 3 of the notice of motion. It says that the third respondents to the 32nd respondents be directed to pay the first respondent any and all sums paid to them respectively under the tender. We submit that this prayer was not properly thought of because it moves from the premise that government is entitled to mess up in terms of its obligation to procure services and that it must receive the services, and after that the SIU can come and say that whatever has been paid to the service providers must be paid back to the government. That certainly is not part of our law. In fact, then I would like to refer your leadership to the judgment that I don't think we have referred it in our heads. It is MEC, Consultant of Police, Roads and Transport versus Terra. Terra is TERRA, Graphics Pty Ltd, trading as Terra Works and another. 2015 for all SA 255, Supreme Court of Appeal, paragraph 21. I'm just going to, it's all SA 255.
All SA, okay.
Yeah, all SA 255 SCA.
SCA.
And paragraph 21, I'm just going to read then the passage, although the passage was written in the context of a department that deliberately flouted procurement processes and thereafter wanted to rely on not being obliged to pay those who have rendered services. I'm alive to the fact that in this case, the department has defended itself to say that it has followed the law when it procured goods and services from my clients. But the principle, I'll say that somehow resonates with what I'm submitting. And the court said the following: it is important that government institutions respect the rights of those whom it transacts. Government should be scrupulous role model. In the present case, the stance adopted by the province was that it had acted contrary to statutory prescripts, more particularly that it had failed to appropriate funds, as demonstrated above and as accepted by the province. That was not the case. The province failed to take any subsequent remedial steps, and it completely ignored the hardships it had caused for those with whom it had contracted. Worse still, it accepted and retained the advantages it gained through the work done and services rendered by those contractors, and steadfastly refused to take any steps to ensure that they received the compensation that was due to them. So that's exactly the point. SIU has to be very responsible when it tries to ensure that the state is not impoverished through malfeasance means. It must take into account a balancing exercise. That is, this organ of state that we have investigated and which we found to have been wanting in accordance with the prescripts of the law, did it receive benefit in a form of that services were rendered to it? And one would expect the SIU then to come with a remedy which say that let those who rendered services be remunerated for the services that they've rendered commensurate with the value received by the government. So that is what we call a just and equitable remedy. But to say that these service providers who responded to an open tender which was transparent and rendered services to the department, they must pay back the money is completely unfair and doesn't accord with any just and equitable remedy contemplated in section 172(1)(b) of the Constitution. What we contemplate is a situation where the suggestion that I'm making, my lady, is predicated on the fact that it is not in dispute that we have rendered services and we have supplied goods, and those goods were accepted by the department. And we're not actually then saying that they must return them back. We don't want them, because then we've given them the goods. As to what they've done with the goods is none of our business. But the fact is that goods were delivered and therefore they are now the goods of the department, and on a quid pro quo basis, then they must pay for those services. It is up to the department to say that the value that we have received from these goods is so much and this is what we're offering to pay you. Then the dispute is just going to be about how much has to be paid for the goods that have been delivered. But what can be is the complete refusal or an order by the tribunal to say that my clients must not actually get anything. Instead, they must pay back the money, and there is even no tender then for them to receive the goods. Even if then there can be such a tender, they have nothing to do with the goods because they never wanted them. It's not like they bought finisher for themselves and which the government asked for. They bought the goods because the government said that buy these goods for us, and the government accepted that. So we're simply then, confined to opposing this draconian and just prayer, which say that our clients must pay them back the goods, pay back the money. And we said there's no justification for that. And we said that that prayer must be dismissed, irrespective of whether the tribunal is going to find against the department in relation to the review. Even if then the tribunal will find that the department did not do things properly, it flouted the transcripts, then the prescripts pertaining to procurement. But what then the tribunal should not do is to grant an order which will be unfair and unjust to the service providers. The department must still be compelled to pay. In fact, if we take the concept, then the approach that was taken by the Constitutional Court in Gijima, where the Constitutional Court found that indeed then CETA was correct to approach the court to set aside a tender which was awarded in favor on behalf of the police for the procurement of ICT services. But then the Constitutional Court said that although the court is obliged when it finds that the decision or an act of an organ of state is unlawful, to set it aside under 172(1)(a. It is not obliged to set it aside under 172(1)(b) if it do not be just and equitable. In Gijima, although the Constitutional Court found that the tender was invalid and ought to be declared invalid, but it said that that should not divest Gijima of the rights that accrued to it as a result of that invalid tender. And we say that the same principle should be applied in respect of the service providers. And we do not want to go further to make other submissions, but we limit our submissions only insofar as prayer 3 is concerned. Insofar as the other prayers, we leave it then to the government or to the department to defend itself, because it is the one which awarded the tenders. Those will be our submissions, my lady, unless if there's anything that we need to canvass.
You certainly heard from my engagement with Ms. Norman that in the event that I find that the SIU succeeds in the review, then the special tribunal has to consider what is the appropriate, just and equitable relief, right? So yes. I hear you saying, in that event, don't divest us of our rights on the basis of Gijima, right? Now, if I'm not with you on that point, but I am considering granting just and equitable relief, what is your proposal in terms of how I'm to frame it, particularly considering what Ms. Norman has proposed?
Yes, yes, that's actually quite important. The appropriate remedy, insofar as the service providers is concerned, should go along the following lines: that in respect of goods that have been delivered by the service providers to the department, those goods then should be compensated for on a quid pro quo basis. And if the tribunal wishes to add, it could even put a rider that somebody or an expert can be appointed to put a value then to what has been delivered to the department. But they should be compensated to what they've delivered based on the appropriate value attached to the goods. That will accord with what your leadership has put to Ms. Norman to say that any order that is granted should not put the service providers in a worse situation than they were before. So they didn't invite themselves. Imagine that you're sitting at home, then you're invited to tender and provide 100 loaves of bread to a department. You go to the shop, you buy 100 loaves of bread, then they eat the bread, and then the next thing they come back, they say that, oh, we've procured unlawfully from you, and then bring back the money. That's absolutely ridiculous.
Yes, but the Constitutional Court has dealt with that issue, Mr. Mukari, quite numerously, and it's become known as the all pay principle.
Absolutely.
Recently, it was in the Shabangu matter that the principle was reiterated.
Yes.
Now, if I find that there were irregularities, surely the respondent entities can be entitled to full payment on the basis of the all pay principle. So they'll simply be compensated for their costs, right?
Well, when I say cost, then it's the value. So cost actually goes to the value. It's not the profit.
Okay. Yes, you were saying quid pro quo, so I didn't understand exactly what you meant. You're quite happy to have the all pay principle applied if I find irregularities, right? Such that your clients don't walk away having lost.
Yes.
They are put in the position they were in before they tendered.
Yes. No, okay. That's absolutely what all pay say.
Yes.
Because all pay, whilst it declared the tender invalid, it still allowed cash paymaster to proceed to render services.
But at no profit.
Well, at no profit, but
yes.
At value. Value in the sense that, profit is what is then calculated after you have deducted everything, all the operations.
All your input costs, yes.
Exactly. So it means that you have to take into account the time that I've spent. You have to take into account that I had to go into the internet. Then you have to pay. So you have to.
We'll get to that point. Yes. We'll get to that point. I actually foresee the approach in all pay where, the legality issues were dealt with, and then there was a part B. Yeah. Where the just and equitable relief is then determined, because there's clearly isn't enough in front of me, to render a judgment in that regard in the event that I find that the SIU succeeds.
Yes, hence I said that, there may be no need to split at this stage, because there are also cost implications. When service providers keep on coming back to the tribunal, they're still incurring costs. All what the tribunal can say is that, then you can make a finding even at this stage to say that the service providers should not be put in a position where, in a worse position than they were when they tendered, but they are entitled then to receive payment on a quid pro quo basis. When I say quid pro quo, I'm referring to it in a sense that there was a give and take. So then we gave, and then they took, and then they must pay for what they have received. But we are saying that on the basis of the calculation that will have been made by an expert. So there will be somebody who then the tribunal can even say that the department, or in consultation with the SIU, appoint an expert who will be able to put value then to what has been delivered to the department, and that be paid then to the service providers, taking into account the cost that they've incurred. And so it's exactly what the Constitutional Court did in all pay, because it then said that I think that it gave the task to National Treasury, I'm no longer sure, but somebody was to evaluate the entire work that is to be done and what it costs, and if it is on a market basis based on the prices that were charged by cash paymaster, how much profit was the cash paymaster was going to get, and then that was deducted. So even here, then, I mean, that's exactly what can be done. So it is ordinarily how much profit were they going to get, and it is the profit that is deducted, but all the costs that they've incurred in order to render that service, that must be paid back to them. So I'm talking about, but it's not for the court to go into the details. The expert will deal with that because they'll be able to say that we spent so much for petrol, then to go and fetch the goods or whatever. All that will be taken into account by the expert, and he will put a figure. What maybe we can do is a structural order in a sense of if there is a dispute about the figure, then the party that is aggrieved may on notice to the other parties or not less than 10 days notice to the other parties, supplement the papers or whatever to come back in order for the court to now make a final determination as to the actual figure. But we're not really in favor of splitting because then it becomes quite expensive for the service providers to keep on coming back.
Okay. I thought you'd go to Annexure MT1.
Well, I mean, I'm taking a different approach, so that's why then I've argued the case this way.
Okay,
yes.
It's your election not to deal with those allegations that are made in respect of MT1 by the SIU?
Well, we've dealt with them. Okay.
Okay, yeah. So you stand by what is.
So we stand by what exactly? Yeah, we stand by that. In any event, I mean, the department has answered the case of the SIU quite well in respect of the merits, especially those matters which don't fall within their knowledge. But what we can say ourselves is that whatever we gave to the department is what we tendered for and is what they've accepted.
Okay, thank you. Thank you, Mr. Mukari. It was short and sweet, so we might finish today because you were so brief but to the point.
Yes. But there's an issue of cost. I see that SIU was asking for cost against us. Even if you find against the department, that was not our decision. Then SIU is not entitled to cost against the service providers. But if the service providers succeed, that they are not obliged to pay back the money that they've received, and that they are entitled to be paid for the products that they have delivered. Remember that it is common cause that there are other products that have been delivered which they have not been paid for, and that the department made an undertaking that it will not pay us until when this matter is finalized. So if then SIU does not succeed to get an order that we forfeit everything, despite that we have rendered services and we have delivered goods, then they should pay our costs, because then the order that they sought against us was completely unjustified and unsustainable legally. So they ought to have known that. If they didn't ask for that, then we're not going to even come into the picture and participate in this litigation. We're simply going to leave it to the department to fight it off because they're the ones who made a decision. But because they came with this prayer, which is not legally tenable, they should pay our costs because we had to come to court and defend ourselves so that we're not left in a situation where we're ordered to pay what we have received and not to receive what we have delivered for.
Thank you.
So those will be our submissions, my lady. So basically we're saying that if you find in favor of the SIU against the department, then it will be, so no cost will be ordered against the service providers, but instead, the SIU should pay the cost of the service providers if you do not give them prayer 3. So they will only be entitled to costs against us if you give them prayer 3, which we have demonstrated that it is not tenable.
Thank you.
Thank you very much, my lady.
Who's next?
May it please you, my lady.
Mr. Thompson.
I appear for the 22nd respondent. That's Pileta Projects. And I believe my lady have scrutinized my heads of argument.
They came last, so my memory is still very fresh. I read them last.
Yes. My lady, as my previous learned colleague stated, the only reason why Pileta Projects oppose this application is because of Prayer 3 and the cost that the applicant sought against the third to 32nd respondents. Although throughout the papers they referred to the first respondent failing to act in accordance with prescripts, the procurement process was irregular and all expenditure relating to this RFQ is deemed to be irregular expenditure. My lady, like my previous learned colleague said, if it was not for that, surely we would not even have come to court.
But you went to the merits. Actually, it strikes me now. I didn't put it to Mr. Mukari. You went to the merits of the review.
My lady, I can submit that we aligned ourselves with the first and second respondent, the process that they followed, and that we could not fault the process as such and the decision taken, my lady.
Okay, anything further?
My lady, basically, I just want to submit, my lady, on behalf of Pileta, that Pileta is actually, or the respondents is in an invidious position, as Advocate Katz has stated. We have delivered, and my lady, Pileta Projects could not identify any of its boxes. So it's safe to assume that its boxes were, the gowns were consumed, my lady. So that places us, the Pileta Project, in a very invidious position.
Oh, Pileta is the one who said their boxes were marked, right?
Pileta,
I saw that even in the answers to the SIU and to the public protector, that was the position. Yes. Their boxes were marked, indeed, but they couldn't find them later.
They couldn't. My lady, we can also highlight here that Pileta made it clear that they delivered at the Provincial Treasury and not at the medical depot or at the Universitas crash. But they went through the exercise. They tried to identify. They could not, my lady. And that places us in a very bad situation, my lady. My lady,
if I grant just and equitable relief, then you're accommodated, regardless of what's happened to your boxes.
Indeed so, my lady. And we also have a claim against the department, an enrichment claim as indicated on the papers, my lady. So
that's for another day.
That is an argument for another day, my lady. But my lady, we submit that the SIU brought us before court with Prayer 3 and asking for cost against us, whereas we had nothing to do with that procurement process. My lady, if SIU should pay the cost, my lady, should the application is dismissed, and similarly, if my lady finds that there was irregularity in the procurement process and the decision to award, which Pileta obviously denies because Pileta complied, my lady, and there's nothing on the papers to gainsay that. My learned colleague for the applicant referred to numerous respondents and them not complying. Pileta has made it perfectly clear on the papers that it complied. And the first and second respondent agreed to that. They admitted that, my lady, on the papers. So, my lady, if the procurement process is found to be irregular and non-compliant, the department should be held liable for a cost, my lady.
But tell me, the issue relating to non-compliance with the Medical Related Substances Act, right?
Yes, ma'am.
Which goes to the root of the procurement criteria. Isn't that an issue that cuts across all the respondents? Because Mr. Nepkin says he contacted the regulatory body, I can't remember whether it's SAPRA or whoever, and their response is that none of the respondent entities were ever or are now licensed for this type of procurement.
My lady, I cannot take that any further.
Okay.
Submitted. I concede that we are not licensed to that, my lady. We did, however, it's on Annexure TSR 9 on page 934. I hope that's to the opposing affidavit of the 22nd respondent. They responded in full to the SIU, my lady, and attached the certificate and so forth. But my lady, as far as SANS is concerned, my lady, I cannot enter that arena at this stage, my lady.
Thank you. Thank you.
Those are the submissions on behalf of the 22nd respondent, my lady.
Thank you, Mr. Duplessis.
Thank you, my lady. My lady, we've been fortunate to be cited as the 27th respondent, and we therefore had the benefit to have access to and align ourselves with the first, second, and other respondents. If it pleases the court, but I do not think with respect that, my lady, that I can add anything else. We will stand by our papers, the heads of argument, if it pleases the court, my lady, unless the court requires any address from us. The court has
nothing
indicated...
specific. Nothing specific from you.
Thank you, my lady. Then we stand with our papers, if it pleases the court.
Thank you. Thank you, Ms. Norman.
Thank you, my lady.
Thank you, my lady. May I just respond to my for the state respondents, Mr. Kass? He continuously submitted that there is nothing that the SIU can point out as a transgression on the part of the department. I mean, that argument, with the greatest of respect, is ridiculous, because the respondents, that is the state respondents themselves, they tell my lady in the validation report that there has been non-compliance with specifications. We have taken my lady through the tender invitation, the bid invitation itself, which makes it very clear as to what certificates have to be attached. And my learned friend makes it look like we're simply talking about a declaration certificate only. There's various certificates there. They are there in the specifications. And it is demanded of the bidders to attach those certificates before or at the close of the bids. That is the 22nd of June. But he continues to make this point that there is no way where the SIU could point non-compliance. My lady, without taking too much of my lady's time, I'd like to refer my lady to the supplement as stated very clearly by Mr. Nathan. And my lady will find that from paragraph, I beg your pardon, my lady, I just, sorry. I beg your pardon, my lady, I think I didn't make a note. These grounds which they accuse the SIU of not having canvassed them, they start, my lady, from page 744 right up to page 107. I beg your pardon, 727.6. And these grounds, my lady, they deal with SAPRA, they deal with SANS, they deal with non-compliance with.
I think, Ms. Norman, you know, when one reads the founding affidavit, because remember the founding affidavit was filed first, right? Before the record was made available to the SIU, and that made it necessary for
them to supplement.
For the SIU to supplement. So there are bold allegations in relation to all the areas of irregularity that you complain of.
Yes.
In the founding affidavit, they are not elaborated upon.
Yes.
But in the supplementary, they're elaborated upon.
In detail, my lady.
In detail, because I was concerned about that, you know, because I battled to get the supplementary affidavit. So I read the founding, then I read some of the answers, And it was only when I got to the supplementary affidavit that I really got to understand what your case is all about. So that criticism is really baseless.
Yes, true. Thank you, my lady. Thank you. And my lady, just on the two aspects, or my lady friend in his proposed draft order, or maybe before I get to that, my lady, if I may just direct the court to page 815, that has paragraph 68 in it. And my lady, observe some of what we regard as concessions made by the state respondent. That's page 815, my lady. But it would be paragraph.
What document is it?
My lady, of the first and second respondent.
Well, I've got a confirmatory affidavit by Mabilo on page 81. Did you say 815?
Yes, my lady. My lady, may my lady just make the reference, record the reference so that when we get the correct page, then we give it to the court.
Okay.
That would be, my lady, paragraph 68 of the first and second respondents' affidavit, which is deposed to by Mr. Sorry, is it? I'm sorry, Mr. Mahlatsi. I beg your pardon, by Mr. Mahlatsi.
Okay.
Thank you. That's where the response is, where there is this submission that they did nothing wrong. Everything was done correctly. And of course, already referred the court to the validation report. And Malene makes then a proposal to the court that maybe as part of the just and equitable relief, even if the court doesn't find for the SIU, the court must still come to the SIU. There is no such obligation created by Section 1721 of the Constitution. Section 1721 says, when deciding a constitutional matter within its power, a court, A, must declare that any law or conduct that is inconsistent with the Constitution is invalid to the extent of its inconsistency, semicolon, and B, may make any order that is just and equitable. So that just and equitable is linked to A. So this tribunal can only have powers if it does not find for the SIU. It doesn't have powers to make any other order. If it doesn't find for the SIU, the tribunal will simply dismiss the application with costs or whatever decision it makes on costs, but it cannot make the proposed order that my learned friend is suggesting.
Yeah. Have you looked at MLO that I was referred to?
Yeah, not in detail, my lady, not in detail, but
I mean, I took that view and then I'm told to have a look at MLO, and I see from the extract that is in their heads, they have it in bold, those lines that says that the court may, that just and equitable relief is not only limited to instances where the court makes a finding of constitutional invalidity. So I was interested in your views on that judgment, if you had read it.
I have not give my mind to it. I simply looked at the interpretation that one would have to give to Section 171, because the Constitutional Court has pronounced, and as my lady has pointed out in the morning, that if you've made that declaration, then you must deal with just and equitable. But where there is no, because in essence, if my lady doesn't find for the SIU, in essence, the court is saying the SIU has not made out a case, and therefore it cannot succeed. So there would be no point, therefore, in saying that I still feel that I must do something about A, B, C, D, and E, because if they had counter-applied, if they had filed a counter-application, it would be a different story. Because then in that sense, to my lady, we don't agree with the SIU on what they are seeking, but we have a problem on delivery. And therefore, we want the court to make an order. There is no such application before you. And I think it would be inappropriate to make any order that is not supported by any application before you. And my learned friend said that my lady could take this matter and place it before an application. and we meet that with a definite no. There is no basis for that. This tribunal is more than capable of handling the matter and deciding on us. Yes, so we don't even want my lady to entertain that thought. Thank you.
I mean, this tribunal can grant any order in terms of Section 8.2 of the of the SIU Act.
Indeed, my lady, indeed. On the statements made by my learned friend, Mr. Mukari and Thompson and Mr. Duplessis, I will simply say, my lady, none of them indicated in their papers that the only basis upon which they were opposing was because order number 3 was being sought against them. Instead, they entered the fray and defended the decision. So if, and my lady finds the SIU, there is no basis. Even if my lady doesn't make the order that the SIU seeks in paragraph 3, there would be no basis for the SIU to pay their costs.
Ms. Norman,
We therefore ask for the relief sought, my lady.
Norman, the judge has
yes, my lady.
Disconnected. The judge has been disconnected. I'm just accepting you in.
Okay, thank you. Okay.
Thank you.
Oh yeah, fortunately it's at the end. Yeah.
Do you want to make the point about the National Treasury Instruction number 5?
Oh yes, yeah, he says.
I think you should say both.
Where did you see that?
It's in our supplementary founding affidavit and in our reply. They both deal with how they contravene to instruction number 5.
Oh yes. Okay. Yes. Thank you. I must do that.
He says we make bold and substantial.
No, man, I simply get when you are arguing. I don't know why it is.
Thank you, my lady. My lady, before we conclude, there's just one aspect that my learned friend, Mr. Katz, had raised, that there is nowhere in the papers where the SIU makes allegations about the contravention of any of the Treasury instructions. My lady, we have dealt with that. My lady will find it in our supplementary. It's there. There's a lot that we say about that. On the issue of cost, my lady, if my lady is sympathetic towards the other respondents, barring the first and the second, we ask at least the first and the second must bear the SIU's costs. If my lady is with us on the orders that we seek. Those are our submissions. Thank you, my lady.
Thank you, Ms. Norman. Mr. Thompson.
My lady?
I thought you were going to deal with your submissions in relation to Marseille.
My lady, I realized afterwards that I should have at least referred to Marseille, to refer to the retrospective, not implementing it retrospectively, where the learned judge that's before us dealt with that specific matter. So, my lady, are fully aware of the judgment. I submit that it should not be retrospectively implemented then, as indicated there, my lady.
No, but the issue there was completely different from what we're dealing with here.
My lady, if one have regard to when an interdict is sought to seek to stop the further implementation, that does not, in those matters, the parties where it was stopped still has to be paid for what they've done until that point, my lady. So that's the
No, but the issue that you raise is different. You are saying there's been performance, therefore there must be full payment, right? That's because on the basis of Marseille, and you are saying Marseille says, it
refers to the mootness of the judgment of the review, my lady, where it concerns Pileta projects.
My lady, you seem to be frozen. I don't know if you are able to hear. Mr. Thompson, it looks like the judge is frozen, right?
Yes, she is. Yes, she is. I'm just trying to get her connect again. I'm sorry.
Oh, okay. No, that's fine.
Right. Thank you so much.
Thank you.
Yeah, Tanya, I see that you're not frozen yourself.
Oh, am I not?
So how are you, Tandy?
I'm good, man. Thank you. How are you?
Oh, good.
Good to see you. Your chambers are like parliament, yeah? The size of parliament.
What else can you do? What else can you do? But I saw that you want to leave us now.
Yes, man. Ish. You know,
No, good luck.
ish.
Good luck.
Yeah.
No, you must go there. You must go there.
Oh, I'll be happy there.
Okay.
Yeah.
No, good luck. It will be okay.
Thank you. Thanks a lot.
All right then.
Sorry about that, Mr. Thompson.
No problem, my lady.
Yes.
My lady, I see there's one frozen screen and then you are there. My lady, what I just wanted to highlight in the judgment is what my lady said is that the review court is unlikely to set aside the tender and contract concluded pursuant thereto retrospectively, as doing so will require the return, like here, the gowns, and such an order will be impractical as it will not restore the parties to their respective positions before the award was made.
Yeah, in fact, that line is slightly legally inaccurate because when a contract is invalid, it's invalid, period, right?
Yes.
When a procurement contract is invalid, it's invalid, period. And then either the court condones the invalidity and allows it to continue or orders just an equitable relief if there's been full performance. But yes, but you can't take those lines in isolation. There's another extract that you've quoted that makes it very clear that the issue that was up for determination there is very different from what is being determined here. Because the right in question there was the right to participate in a fair procurement process.
Yes.
Right. So if the interdict was not granted, then Marseille would have lost that right forever.
That is indeed so, my lady.
Yeah. Because if the tender is stopped, there could be a rerun. In fact, the judgment says so specifically.
Yes, ma'am. No, I'm with you there, ma'am.
Then that issue doesn't arise here because here there's been full performance.
Yes, ma'am.
And then what would arise is then the issue is whether the irregularities should be upheld, and if so, what should be just an equitable relief, or the SIU does not succeed, in which case the parties are then at liberty to continue with their contractual arrangements.
Indeed so, my lady. I'm with you there.
Okay. Thank you very much.
Thank you. Thank you, my lady.
Thank you for largely complying with the directives. You know, the parties, this is very much your process. We are required in terms of the Act to determine matters expeditiously, but it's really up to the parties, you know, and where the parties are diligent in complying with directives, matters do get a forum as soon as possible. So thank you very much for that.
Thank you very much, my lady.
I know that the matter, it took a year to get here, but once we got case management going, then the matter just flowed very, very efficiently, right? So I just need your patience with the delivery of the judgment. It's not an easy one to consider because there are novel issues that arise here of a huge importance, not only to the parties, but to the industry as well as the public interest. And I've been inundated with huge matters. So I will take maybe about 6 weeks to hand down this judgment. So just be patient.
Thank you, my lady.
Thank you,
my lady. Thank you.
Thank you, my lady.
Thank you.
Thank you. Proceedings are adjourned.
Thank you.